Good morning. The hearing board is in session. Today is Wednesday, August 31st, 2016. The hearing board is meeting in the hearing room at AQMD headquarters in Diamond Bar. Time is 9:05 a.m. Today we are hearing in the case of SAQMD versus Sunshine Canyon Landfill, case 3448-14, an objection to subpoenas, requests, and motion in limine, and perhaps some other matters. I expect before the end of the day we will set a schedule, briefing schedule and hearing schedule for the remainder of this matter. Who is representing the executive officer this morning?
Good morning, Nicholas Sanchez on behalf of the executive officer.
And
Mary Reichert on behalf of the executive officer.
Thank you.
Good morning, Mr. Chairman, members of the hearing board. Tom Bruin on behalf of respondents.
And good morning, Bill Beck on behalf of respondents.
Good morning, all. Gentlemen and lady, we have one attorney on this board. The rest of us are lay people, and two of the board members are recent appointees. So I'm going to ask you, when you make your opening statement, to make it in lay terms and help us understand exactly what it is you're asking for. Okay? In as much as this was triggered by a request for subpoenas and subpoenas due centicum, and also there's a motion in limine, both of which were initiated by the respondent. Perhaps the respondent would like to open first.
Yes, thank you, Mr. Chairman.
Excuse me, Ms. Prusek wishes to make a comment.
Just to the extent each party addresses the proposed protective order that is before us when the time is right, I would like both parties to address how that will work in terms of the public nature of these hearings and the fact that everything that is introduced as evidence becomes essentially a public record. So I'd like to have the parties address that specifically when the time is right.
Excuse me, Mr. Chairman, over here, Paul. As there's dialogue going back and forth, people don't need to continually flick their mics. As there's normal dialogue, they can leave their mics on during that. As you're speaking to the attorneys, it's just long periods of silence. That's all. I wanted to make that clear. Okay? Thanks.
Thank you.
So, Mr. Chairman, perhaps the best way to start is to talk about the things that we think we've resolved with district council, because I think we've narrowed the issues significantly as to what disputed items the hearing board needs to address today. With respect to our motion in limine, first of all, I really don't think we need to spend a lot of time on that motion, because I believe the proposed hearing schedule that we've worked out with district council addresses our concerns with respect to making sure we get the district's documents sufficiently in advance of the hearing so we can prepare our defense. So if the hearing board adopts the proposed schedule that's been presented to you, that's acceptable to us, then that dispenses with the need to address our motion in limine. With respect to our subpoena, there are 30 categories, I believe, of items that we've requested, and we've reached agreement on 23 of them, subject to this protective order dealing with the complaint records, which I'll talk about in a minute. And there are, let's see, there are items 21 through 30, which are somewhat in dispute, mostly because the district was concerned that there wasn't any time period specified in the requests. So in our reply memorandum, we've suggested time periods to reduce the burden on the district of producing the records We haven't heard back from the district as to whether those time periods are acceptable. I imagine we'll be discussing that this morning, but we're hopeful we can work that out as well.
Mr. Chairman, I see the respondents' response to the motion to quash the subpoena for protective order. I don't see the motion to squash.
We did receive a motion to quash from the district. It's part of the record, so that was what we were replying to.
I don't have that. The motion to squash, no.
You don't have that document?
I do not have the motion to squash.
Okay.
Does anybody? Okay.
That was in the,
It was included in that? Proceed.
let's proceed.
All right. So maybe I could address then the stipulation and protective order. The hearing board is aware, I believe, that we had filed a petition in the Superior Court under the Public Records Act, which was denied by the Superior Court judge. We had also, in the class action lawsuit, filed a subpoena on the district for complaint records, which the Superior Court judge in that case ordered the district to produce pursuant to a procedure called the Bel Air procedure, which is one in which you send a notice out to everybody that's filed a complaint and say, do you object to having your complaint records disclosed to the parties to the lawsuit, both the plaintiffs and defense counsel. About 9% of the complainants objected, so we've got 91% of the complaint records produced to us by the district up to February of 2013 in that lawsuit, and we had a chance to analyze those complaint records. 2014, excuse me. So the stipulation and order that we've worked out with the district council is in lieu of our filing a appeal of the Superior Court judge's decision in the Public Records Act case, and it provides for the disclosure to us of unredacted, and by that I mean undeleted, complaint records for the period of October 2013 to the date of filing the petition. And this protective order pretty closely mirrors the protective order that Judge Freeman issued in the class action lawsuit. And basically, the point of the protective order in the class action lawsuit was to limit the use of complainant names and addresses to the, the litigation in that case. And as a practical matter, what we want to do with the complaint information is to do an analysis of how many different homes have in fact lodged complaints against the district, where are they located, when were the complaints lodged, and that sort of thing, because we think it's important to a determination of how many people really are complaining about odors from the landfill. So to answer Ms. Pressick's concern, we weren't ourselves, at least initially, planning on introducing all of the complaint records as an exhibit in this proceeding. And I don't know at this point that we're really going to need to identify individual names and addresses. I can't swear to that. There might be people who testify in the public hearing. But the main goal of obtaining these records is so we can present an analysis of how many different homes complain and where they're located. We think that's important to present our defense, because it goes to the question of just how many people say they are bothered by odors from the landfill. Where do they live? Where are they located? We think that's really important evidence in this case. So we think this proposed stipulation of protective order is the best way of allowing us the ability to look at the records and present evidence regarding those records so we can present our defense, and at the same time, to the greatest extent possible, protect the confidentiality of those people who've complained. So we would ask that the protective order that we've worked out with the district council be granted by the hearing board. So assuming it is acceptable to the hearing board, then I think the only other remaining item we need to talk about is whether the proposed schedule is acceptable.
Mr. Chairman, would the district want to comment on just was stated?
I didn't hear what you said.
That's what I was about to say.
I think the assumption is that we're going to sign off on the request, and I'm saying if that's, okay, go ahead.
You may proceed, Mr.
Oh, I was just about to say that I think the items that we need to address today, therefore, are the various items in the subpoena, which we've suggested time periods for that we don't yet have agreement from the district council on yet. And we do have a few issues with the proposed schedule. There are minor comments and clarifications we'd like to discuss at an appropriate time. And that's what I have so far.
Mr. Sanchez.
Thank you, Mr. Chairman. The core request for the information in this matter began with requests for unredacted complainant information. That information is of the highest priority for the district to keep confidential. And so we go through different safeguards to do so. Initially, Mr. Bruin's firm requested that information through a Public Records Act request. And as he's indicated, it was previously requested in the class action lawsuit. Both judges in that case identified that information as the people providing that information to a government agency as having an expectation of privacy and it being considered official information. There is a difference in the analysis after the designation of that information. Its need for an individual to defend themselves in litigation is seen differently as opposed to the public wanting to know that information through a Public Records Act request. The district filed their petition for an order for abatement in July. The respondent filed their petition in Superior Court to get that information through Public Records Act shortly thereafter. The district signaled to respondent the information was probably best acquired through a subpoena before this hearing board. And so shortly after the denial of the writ for the information through a Public Records Act request, they indicated to the district they would be seeking that subpoena and filed it the Friday, 2 days after that decision. The district has raised their concerns on why this wasn't pursued sooner, but ultimately we need to, what the district is trying to achieve in this matter is to reduce odors in the community. And so ultimately we need a good record, we need evidentiary basis for what the district is seeking, and we need the district to get its due process in defending itself in this case. So based upon that, the district was willing to enter into a protective order solely for the complainant information, and we asked that they agree to, which they did, that it only encompass the time frame which is the subject of this order, which is October 2013 through July 2016. Ms. Prusak brings up an excellent point because this is a proceeding subject to the Brown Act, as well as the records of this board being subject to the Public Records Act. We've sought this protective order so that information is not made part of the public records and is segregated separately from that. As I indicated at the beginning, not providing the complainant's identifying information but for these proceedings is the intent of the district, and we would only agree to produce that under those protections. So anything received by the clerk, anything presented by the parties, that it not be available on class or that the clerks go through their normal process when accepting that information, that it be segregated and be under protective order, and that it be returned to the district following the conclusion of the proceedings. That's what the district is seeking. We cannot prevent people that identify themselves as part of these proceedings, that they have made complaints against the district. And the district, in fact, will be calling some of those people as witnesses. So there is a line we will be towing throughout this process where, in the district proving its case, people will need to be identified and they will be subject to cross-examination. As we saw at the last proceeding, someone identified themselves. That will be inherent as we go along through this process. What I wanted to add is ultimately, the board in this case, as in others, they will need to make credibility findings. And so the records may come at issue in terms of what's represented to the board in the public proceedings and what may have been represented in a complaint to the district as part of its enforcement activities. The board will need to rely on those records in making determinations on how they weigh the evidence and how they determine whether there's an ongoing public nuisance. But as far as the mechanisms and the procedures, I would ask that the board receive the evidence or the records be admitted in evidence, but they be segregated from the normal record that's available to the public as part of this process. Going towards the first motion brought by respondent and the motion in limine, it's a district position that they are essentially seeking to preclude the district from proving its cause of action for nuisance. And so for that reason, we're opposed to that motion. And all evidence is prejudicial. The question is whether that evidence is unduly prejudicial. I believe respondent has indicated if, with the protective order, that should address that issue. And so I would ask that the board dismiss or respondent withdraw their motion in limine based upon what I heard in the opening statement. Regarding the subpoena that is before the board, I believe items 1 through 10 will be addressed through the protective order. But for the time frame that the district has requested and respondent has agreed to from October 2013 through July 2016. Regarding items 11 through 20, I would describe those as policy information. I would, again, just ask that the board limit production of that information from October 2013 through July 2016. And as I indicated in my motion, any objections or privileges or confidentiality claims that the district would claim in producing that information, it would be identified in a privilege log for respondents' clarification. Regarding items 20 through 23, those specifically deal with information regarding District Inspector Larry Israel, regarding phone communications, communications between the district and complainants, and communications, and information regarding Mr. Israel's compensation or overtime related to his work on Sunshine Canyon landfill. It's the district's position that any information that Mr. Israel has gathered as part of his issuance or enforcement activity regarding the last 3 years on Sunshine Canyon landfill, that would be contained in the enforcement records or NOV records that will be produced under protective order. And anything beyond that is not beneficial to this process, is oppressive and burdensome, and is not necessary or will make an ultimate determination on the findings of this board. If respondent chooses to examine Mr. Israel on any of those topics, they're free to do so regarding his, basis or justification for issuing NOVs. However, I don't think his overtime or compensation records have any bearing on the outcome of these proceedings, and would ask that the board quash those item numbers under the subpoena. Regarding items 24 through 30, those relate to sampling that the district has taken regarding Sunshine Canyon landfill.
Excuse me, which were the numbers that you just mentioned?
24 through 30.
Thank you.
Those regard any sampling efforts the district has taken, or scientific measurements or analysis that they've done regarding the landfill. Again, I would ask that the time frame be limited to the last 3 years for that time frame, and any objections or privileges claimed by the district, it would be identified in a privilege log for respondent. Regarding item 31 and 32 and 33, I don't believe I raised any objections to those items. I believe I've identified the information in the time frame at issue for those items. However, I would just clarify that we were just provided an ultimate report by Dr. Yazdani and Hydrogeochem. Those are not employees of the district. And so I would only have records regarding my communications with them directly. I would not have the ability to make them produce anything that I did not obtain other than my communications and developing those final reports. And then last, on number 33, again, I do have the information responsive to that. But for 31 through 33, I'd still like the ability to raise any privileges or claims of confidentiality, and I would identify that in a privilege log. Last, regarding the proposed schedule, the parties did not stipulate, but gathered dates to propose to the board in order to determine the schedule going forward, including exchange of witnesses, experts, and the time frame for the two cases. Once the board makes its determination on the other matters, I would also like to clarify for the board, depending on the extent of the subpoena issued today, the district would estimate that it would take between 4 to 6 weeks to gather all those documents. We would like to do so on a rolling basis. We would quickly be able to, we're in the process of scanning some missing information that is not, we don't have all the NOV reports scanned into our records yet, but we are in the process of doing so. So that would be immediately provided to respondent. And then we would just need to search the district's records to produce the remaining documents. So we would estimate a 4 to 6 week time frame to comply, depending on the extent of the subpoena issued before the board. Thank you.
Ms. Byrd?
On the document for the stipulation and protective order on page 2, at the line 2, I'm assuming that should have been July 12th as well, instead of June 12th?
Yeah, let me double check the date of the petition. 1 second.
I believe that is the date the petition was filed, so.
No,
No, I meant to say July. It should be July, not June.
no. The document we received today, the stipulation and protective order on page 2, line 2.
Yes, it should be July
July.
12th,
Okay.
not June 12th.
Thank you.
Ms. Prusay?
With regard to, Mr. Sanchez, you were mentioning a time frame. So if we're looking at this proposed schedule, so to understand it, August 26th is the filing of the motion in limine. You're saying 4 to 6 weeks on a rolling basis for production of records by the district, and 4 weeks thereafter for the respondent to prepare by reviewing those documents. Is that what we're looking at?
I would ask, based upon the timeline and the respondent's choice to proceed in getting the records, that we get the earliest possible date. I think my position would be the core documents and the ones that respondent has sought relief from judicial review on has been the complainant records unredacted. We should be able to get them, all those records, by next week. And so I would ask that, you know, they can raise, after receiving those records, how soon they could be ready to proceed. But I would say, based upon next week, being able to get them all the complainant records unredacted, that we get the earliest possible hearing date based on that assumption.
So, where did I see it? I thought in the proposed schedule, we just got this, but I believed I saw, yes, the hearing will begin 4 weeks after petitioner produces documents. So you, Mr. Sanchez, you were part of the, or at least you discussed this proposed schedule, is that correct? With the
Yes, and I'm sorry, I'm assuming that my conversation with the clerk was communicated to the board. So for the stipulation, for the protective order, the parties are in complete agreement on that. Regarding this proposed schedule, the parties have negotiated but have not reached stipulation on the proposed schedule. So that is a combination of proposed dates by the party, and I believe respondent can address, they had some additional items they wanted to add to that, but we have not reached stipulation on the proposed schedule, but we did want to get the board something to review.
Okay, and does the district have a position with regard to a date? I know you stated the earliest possible date. Is there a position as to, so then we can ask respondent its position as well?
It looks like that would be the second week of October, but I think we'd also like to keep in mind, maybe we determine the total amount of the hearing dates first, because the district would want at least 2, possibly 3 hearing dates on Saturdays in the community. But based upon what we would schedule is getting them all the information next week, and respondent has indicated they would need 4 weeks to prepare. That would bring us into, I believe, the second week of October. But if we can shorten that time at all, based upon the board's determination, I'd ask that be done.
I have other questions, but I'll wait until we determine how we're going to go about questioning.
Any other questions for the parties? My thought is, for us to take some time to review what's been the protective order and the thoughts expressed in the opening statements by the parties, and then come back and deliberate, or perhaps ask more questions at that time. Mr. Bruin?
Yes, Mr. Chairman. Assuming the district's complaint records are produced to us by next Friday, a hearing start in the second week of October will work for us. We do want to obviously get the other records we've requested before the hearings start as well, but the pacing item for us is getting the complaint data, so that would be acceptable. If I can just make a few comments, I think we can resolve some other issues, so if you have less to think about. And that is, Mr. Sanchez had proposed for items 24 through 30 that they would be willing to produce those documents generated in the last 3 years, and that suggestion is acceptable to us. So that leaves unresolved only 3 categories. Well, I take it back. It leaves unresolved categories 21 through 23. And then I heard something which I don't think was in the motion to quash on items 10 through 20. Those 10 items relate to the district's policies for investigating and responding to odor complaints. And Mr. Sanchez said he wanted to limit that to documents generated since October of 2013. My concern about that limitation is I believe the district's policies for responding to odor complaints and NOVs are longstanding, and there can't be that many. I don't believe there are that many, so it seems to me putting a time limit on it is going to mean that relevant guidelines and practices are not going to be disclosed to us unless you interpret Mr. Sanchez's statement as to any policies that were in effect during that time period. And if that's what he meant, then that would be okay, because all we're looking for is any written policies or procedures that the district has for responding to odor complaints that were in effect from October 13 to the present. And perhaps with that clarification, we were in agreement, and that would pertain to items 10 through 20.
I would agree to that restatement.
So it would be just the policies and procedures during the period October 13th through July 16th that would be produced.
That were in effect during
In effect.
So just to help boil this down, then we have a disagreement on items 21, 22, and 23, which I'd like to be heard on at some point.
Okay.
And I think that's it for the subpoena. If the hearing schedule we're talking about is acceptable to the board, then that resolves our motion in limine as well. And so then the only other issue is whether the hearing board has questions about the protective order.
Ms. Broussard?
May I suggest that before we take some time to review, that Mr. Bruin be heard on the remaining issues and the motion to quash numbers 21 through 23, because as I recall in his opening, he reserved that right, being as he had not heard a response from the district, and now that he has. And then I have a question for the parties to consider about the protective order, but maybe we should hear from Mr. Bruin first.
Thank you.
Mr. Chairman. Right. I just heard the more recent request that of the policy as relates to gathering information. Mr. Sanchez, is there a policy written whereby information on witnesses are provided, redacted or unredacted?
What we do have is we have a statement on the district's website regarding filing odor complaints or any complaint and the expectation of privacy, and that, you know, we object, but for court orders or pursuant to the Public Records Act, that we produce that, if that answers your question, Senator.
So you have, your practice has been not to provide the information unredacted when requested, is that correct?
Through Public Records Act request. We have different, it's not a one-size-fit-all process.
I understand, public record, right. But in this case, you're willing to, under protective order, to allow that to happen?
The reason being, as I indicated in my opening, is because this is a contested matter, and so we are alleging a ongoing public odor nuisance. And so has been analyzed in the two court decisions and has been ordered in one of the court decisions, the court has distinguished the ability for a defendant to defend themselves against allegations of a public nuisance as them being afforded due process. And so obviously this isn't a criminal proceeding, and not all exculpatory material is required to be provided, but it is still a proceeding where there are ramifications if there are findings against a facility. And so based upon that, we are willing under protective order to provide information in which the district relied upon to pursue its enforcement actions.
But in that class action lawsuit, you were present when the request was made to release the information unredacted?
Yes, we fought that matter. We fought it before that judge. We fought it before the Court of Appeals, and we fought it before the state Supreme Court. And
In each case, you prevail?
No, we did not prevail in that case.
In what circumstances did you not prevail?
That the judge determined that due process and fairness required that a defendant or a respondent be allowed the information to defend themselves with complainant information.
During those court hearings, were there other attorneys representing the class there present?
The district is not a party to that matter.
Were they?
Yes, parties for both sides.
Right, where the information was being requested?
Right. The petitioners, or the plaintiffs and the defendants in that case, wanted the information. The district fought to withhold that information and did not prevail.
From the plaintiffs?
From the subpoena was filed by respondents. The plaintiffs did not object to that subpoena. They were in support of that subpoena. And so the district, as a non-party to the matter, fought production of that information.
Would you be of the opinion that the attorneys representing the plaintiffs that were involved in that litigation would have any interest here? And if they were in this proceedings today, would they?
I don't know what their.
Were they notified that this this request is going to be made for information relating to their clients?
We see this as a very distinct and separate action from that action. The remedies being sought are separate from that action. And so although we do have matters before this board where there are parallel actions, the interest of those parties is separate from the districts. I would expect that the people that are impacted by this would notify their attorneys, as often happen in these type of matters, but what they know and what their interests are have not been communicated to me.
Well, they are a third party in interest, I think, since they were involved in the case initially in the court's proceedings. And there's a requirement that the third party of interest be notified that an action like this is being requested so they can participate in the process. That's what third party interests really represent.
I don't think there's such a requirement here. I think the timeframes that are at issue, as which we've narrowed down before the board today, are different. That action was filed, I think, many years ago. The complaints and enforcement actions that the district had pursued during that timeframe have already been resolved. And so I don't think there's obviously a relationship, but it's not of a judicial nature where any notice to those parties are needed. But I can tell you that one of the parties involved in that is involved in this case, so they may be able to answer some of your questions because we're not involved in that litigation.
What we finally determine here, Mr. Chairman and members, is going to be made known to the opposition eventually in that class action lawsuit. And if the issue, I'm just a member, so I'm not a lawyer, but if the issue is subsequently raised during that lawsuit that action was taken here without they having known, without they having known or to participate, would that cause us any problem?
I don't believe it does, but just to take a step back and kind of give you some perspective on what was done in that case and what's being sought in this case. That was a class action lawsuit. That type of proceeding, as I learned, being involved in it, has a very different discovery process.
Oh, shit. I'm sorry. Proceed, I'm sorry.
Sure.
sir.
Judge Freeman put in and I believe that order was provided to the board. That Judge Freeman, put in very numerous safeguards, some of which are unique to class actions. The information provided was provided under protective order. A third party, an independent third party received that information and contacted, as we often all receive, postcards regarding class action lawsuits. Their response to that information determined whether the parties could receive the information, and then the parties were required to demonstrate good cause to that judge before they were able to contact those parties. The Bel Air notice that Respondents' Counsel referred to is unique to class actions. We fought that process be used in the Public Records Act request, and we don't think it's appropriate and would cause further delays in this matter. So consistent with the protection of the information solely for this matter, the district was willing to enter into a protective order that the information would not be available but for these proceedings.
I see the proposed schedule. Is there any likelihood that there'll be additional hearing in the class action suit prior to this?
I am not aware of any. I was tracking the matter when the district was required to produce information and was subject to a discovery order. I have not been tracking the matter for some time now.
But hypothetically, what if it were going to proceed and the information has been provided unredacted to the respondents? What would preclude them from calling them up as, deposing those individuals?
What ultimately, the discovery that was provided will be different in the two cases. The time frame is different. I trust, as officers of the court, the respondent will comply with any discovery order that this board would issue and the protective order that is in place in that matter.
Through the chair, if I may respond just some of the senator's questions, I might be able to provide some useful.
Mr. Brown?
Yes, thank you. Senator, that class action lawsuit has in fact been settled. We have a draft settlement agreement. We've agreed that a retired judge of the Superior Court, Judge Tim McCoy, is going to be involved in the process of distributing some of the settlement funds. So we're going to shortly be filing a motion for preliminary approval by Judge Freeman of that settlement. So there won't be any depositions or discovery in the class action case because it's settled. The other thing I just wanted to mention is there is a statement on the district's website for people who are going to phone in complaints to the district that says a couple of things. One is you don't have to give your name and address, but if you do, and people are encouraged to give their name and address, it says that if you do give your name and address, it may be disclosed in any public, pursuant to the Public Records Act or pursuant to a subpoena or for use in any legal proceedings. So members of the public are cautioned or told that when they deliver a complaint to the Air District that if there's a legal proceeding involving their complaint, that information can become public. So it's not it's not that people are assured that their complaint information, their names and addresses will be absolutely confidential in all circumstances.
Thank you so very much. But my next question then, is there any likelihood that the respondents would file a cross-complaint against some of the people who raised the initial question in the first place?
No.
Okay, thank you.
Ms. Brissette?
I just wanted to get back to my initial question and issue with regard to the protective order. And looking through the protective order, it makes a lot of sense in private litigation and in the court context. It certainly protects complainants with regard to turning over the information to respondents to be reviewed and used in this particular proceeding. But again, this is a public hearing pursuant to the Brown Act, and I don't see anything in here with regard to any kinds of protections from disclosure during the hearing. And I'm wondering if, while we take a break for the board to review the documents in light of the opening arguments, if the two parties could come together and see if there can be some discussion or a meeting of the minds with regard to an additional condition, perhaps any evidence that is presented to this board, if specific names and addresses can be redacted, at least when presented to the board, if that's a possibility. I just want to look for some kinds of protection to members of the public who made complaints that their names and addresses not be aired publicly throughout this hearing. So if there's a possibility of presenting us with something that can help us protect that, I would appreciate it.
We can do that.
Thank you.
Would you like me to address those three items before you?
Yeah, please.
So this relates to items 21, 22, and 23. The first item is any communications between the district and Larry Israel, who's the inspector for the district that's been assigned to the landfill since 2009 and has issued 95% or more of all of the NOVs to the landfill. We're seeking communications between district management and Mr. Israel regarding notices of violation given to Sunshine. That might be a memo, it might be an email, or whatever. We've agreed to limit the time period to any documents that were generated after January 1, 2012. We think it's important because we believe a lot of the instructions given to Mr. Israel for investigating odor complaints and issuing notices of violation are not embodied in any manual of procedures or rules or guidelines of the district, but rather were communicated really sort of on an ad hoc basis. By that I mean Mr. Israel sought instructions from management as to how to do various things in responding to odor complaints and issuing NOVs, and we believe that those were communicated by email or memo, and that's what we're looking for here. and we've agreed to limit the time period to January 2012 to the present. Mr. Sanchez said, well, that information will be in the notices of violation. We respectfully disagree, because the notices of violation will show that he gave the landfill a violation. It won't show what instructions his management gave him as to under what conditions he should issue an NOV, and that's what we're looking for here. With respect to item 22, we're looking for phone records between Mr. Israel and the complainants. He has a cell phone given to him by the district. He was deposed by the plaintiffs, and we were also given the opportunity to ask him questions in a deposition in the class action lawsuit. We know he has phone conversations with people in the area who have filed complaints, and we're just looking for records of when those conversations took place, how long they were, et cetera. And then on the question of overtime, we know, again from Mr. Israel's testimony in the class action case, that when he comes out to the landfill at night, he gets overtime pay. We've always had a disagreement with the district over giving overtime pay to inspectors at night, because we think it gives them a financial incentive to confirm odors and issue NOVs, because if they stopped, people would stop complaining and they wouldn't get the overtime pay. And we have complained for some time that the district should put more inspectors on the landfill, so we'd have different individuals with different sensibilities, et cetera. We think the question of the amount of overtime pay goes to the question of whether there's a potential incentive or bias on the part of Mr. Israel to confirm odor complaints and issue NOVs. I will say on this subject of compensation, I'm general counsel to 2 public agencies that are solid waste authorities, and every month I get a check for my services, and it's a public record. And if you look at the district's website, it'll show for, I think, all of the district's employees, name, regular salary, overtime compensation. So this is publicly available information. It's not a secret. And we're simply asking for the overtime compensation that Mr. Israel earned in the years 2013, 2014, and 2015 in responding to complaints regarding Sunshine Canyon. So there's 3 numbers, 1 for each year. That's all we're asking for here. We think it's a public record. We've asked for it under the Public Records Act. Frankly, I think they're required to give it to us under the Public Records Act, and it's relevant to our defense. So those are my comments on those 3 items.
Mr. Chairman? So, you sat in on the deposition when Mr. Israel was being disposed.
Yes, sir.
You had an opportunity to ask him questions, is that not correct?
I did, yes.
Did you ask him any of these questions that you're asking us today
Well,
at that time?
yes, we did. We asked him about instructions from his management about phone records and about overtime compensation. He didn't give us the number, but he said he did receive overtime for responding to complaints at Sunshine. I asked him for phone records at the time. He said he didn't have a cell phone. We've learned since then that he does have a district-issued cell phone, and perhaps that was issued to him after his deposition. With respect to communications with his management, he did indicate that he received instructions from management. I believe those would be most likely not all verbal, but in emails and memos, and that's what we're seeking.
When you talked about overtime, what was the time frame that he was working that you would consider to be overtime?
I don't know what his regular hours are, but I believe they start early in the morning, and that by the time 5 p.m. rolls around, he's off the clock, so to speak. And I know that he's responded to a number of odor complaints at night, and I believe he's received overtime for all of those responses.
So did he tell you that he would respond only when requested to do so by did he respond by supervisors to the district to determine whether or not there's an odor, or did he just respond on his own?
If I understand the question, I believe Mr.
Excuse
Israel.
me, Ms.
Yeah, I'm
Brusette
asking
has-
him a question, Mr. President.
I just want to make sure we're not getting into actual
No, we're not.
evidence.
We're not. I'm just asking. He made the statement that he was at the deposition. He had an opportunity to ask questions. So I'm asking, what did he ask?
I don't think that's, I have to be honest, I don't know how that's relevant. I think right now we have a request for certain documents and argument as to why they should be produced in this litigation, well, in this case, in this proceeding before this hearing board, and I don't think it's appropriate to get into depositions and cross-examining counsel on what was or was not asked or answered in depositions by witnesses who are not present.
Well, the counsel for the district objected to providing the information, I believe. That being the case, please permit me, thank you. That being the case, the responding attorney had an opportunity to ask the question, did in fact ask the question, and if they're not to their satisfaction, they're not going to understand. But I don't think we need to repeat that, which is the question that's already, respondent has already been asked and answered. This member is not going to do that.
Ms. Brusek?
Just to remember, this is a separate proceeding, so any evidence that is presented needs to be presented as part of this hearing. So a deposition from a different proceeding would not be evidence in this proceeding. So I believe that's why respondent is separately asking for that as part of the subpoena. Whether we grant it or not is a separate matter.
Thank you. I do have a related question that I think the answer to it will help me make a decision on item 22. Mr. Bruin, when an inspector receives an instruction to respond to a complaint that would result in overtime, he has no choice but to respond. How does that overtime payment create an issue where he has an incentive to do whatever to increase his overtime pay?
Basically, the issue is this. If you are called to confirm orders and to issue notices of violation, which complainants want you to do, let's assume hypothetically that for 2 months, 3 months, whatever time period, Mr. Israel didn't confirm any order complaints or issue any NOVs. We think people would stop complaining. So there's a financial incentive for him to confirm some odor complaints and to issue some NOVs because it continues the volume of complaints that come in, and the more complaints that come in, the more he gets paid.
Mr. Sanchez?
I would just say that, some of these arguments are extremely speculative. As I relayed in my opening statement on Saturday, and deservedly so, the district's policies can be challenged, they can be questioned, but ultimately, the district's policy will have to be substantiated and justified. To dig unreasonably beyond that, when Mr. Israel will be available for examination on his motivation, on whether he's biased, this information is not going to give any additional clarity or insight, I believe, to this board on determining what his motivation is. And as I believe the chairman's identified, absent him receiving a call, which is reflected on what was the instigation in the NOV reports to prompt an odor investigation, that's really where the analysis should begin. What his payment is after that trigger begins is really too speculative and quite far-fetched to say that somehow he triggered or motivated. Those questions can be asked, but that's, putting the cart before the horse, and that's what initiated an odor complaint or enforcement action by the district.
Thank you. Board members, any other questions regarding item 22? Excuse me. I didn't hear you. Okay. Ms. Byrd has a question on item 23.
Well, it's 23, and I just wasn't clear with, Mr. Bruin, with what you said. I think you said that district pay employees is listed on the website. Are you referring to the job description listing of salaries, or?
Yeah, there's a
Oh,
job,
okay.
there's a job
Okay.
description on the website.
Okay, so it wasn't by specific individual that you refer, okay, thank you.
I think I have seen documents that were on the district's website that had individual compensation information. It's been a while since I've looked at it, but I'm pretty certain it was there. Not for current years, but I think I saw it for 2012 or 2013.
Okay, thank you.
Mr. Sanchez?
I believe it is on there. I think following the events in Bell, the controller's office required all state agencies to disclose that information. If it's supposed to be directly available on our website, but if not, I think the controller's office, there's a database to search for individuals on that. I think there is a category for overtime. I don't know what's reported by the district in terms of, but we do comply with those requirements.
Thank you.
Any other questions on item 23? Okay. Any questions in general before we go off the record? Apparently not. The board will go into recess for at least half an hour. I'm determined at this point to review the documents and what we've heard this morning. We're in recess.
Before we open the record,
We're back on the record. Mr. Sanchez, during the break, has distributed a written condition to add to the proposed stipulation and protective order. Mr. Sanchez, would you wish to describe it for us?
yes, there's actually 3 items, Mr. Chair. You should have been provided a
Yes.
3-page document. So I would add, based upon Vice Chair Prusak's questions regarding protecting people's identity to the maximum extent feasible, the parties have agreed to 3 additional conditions to be inserted in the order. The first being, any identifying information presented to the hearing board pursuant to the protective order shall have the identifying complaint information redacted. Second, any summary analysis information presented to the hearing board shall identify complainants by code and shall be presented in a way that prevents identification of complainants' addresses. And last, any complainant called as a witness to testify shall be deemed to have waived non-disclosure of identifying information. Thank you.
Mr. Bruno or Mr. Beck, would you like to add to that?
I would, and there's one edit I've got to make in this before we can say it's agreed to, and that is The word prevents in the second paragraph is a little strong. Prevents would have me making it
Second
impossible.
paragraph of which condition?
Sorry. It's in the second paragraph, which says, "Any summary analysis information presented to the hearing board shall identify complainants by code," which is fine, "and shall be presented in a way that," this says presents, I think I would say does not include, and then it proceeds with identification of complainants' addresses. I don't know how I can prevent people from identifying something because I don't have any control over them, but certainly what I present will not include complainant names and addresses for the information subject to that second paragraph. So substituting does not include for prevents, I'm fine with that, and we're fine with the other two. I will say that there's kind of an open issue that we discussed in the hallway and didn't reach agreement on. I should just flag so that the board knows it might come up. Just in order to help the board visualize, as we would with any party that's trying the facts of a case, help the board visualize where a complainant is relative to the landfill, perhaps relative to the school, or to a soccer field, or to another odor source, which might be the water treatment plant or a specific manhole, certain items that we think are sources of odor in this community that have nothing to do with the landfill. We intend to use imagery. We intend to take a Google Earth satellite picture and put things on it. And in putting things on it, we've got to indicate where the complainant's locations are. So that if a person saw that on a webcast and said, I'm going to go get that same image and drill down and see if I can figure out who lives in that place, I can't really prevent that from happening. I can keep from naming them, but if I'm going to effectively communicate with the board the information that we think is important about these complaints, I'm going to have to use imagery. And so we tried to come up with agreed wording that would address that situation. We really couldn't come to an agreement that solves it. And I just need to alert the board that that's sort of the open question is, if I put up a map on the board and we show that there's a particular house that has X number of complaints and is in the Google group, let's say, or is next to this manhole, let's say, then it's possible somebody could look at that map, and if they try hard enough, they could figure out who that belongs to. And I wanted to alert the board to the fact that we really don't have an agreement to take care of that, and that it could come up. And we're happy to discuss it as long as you want. We just couldn't reach an agreement in 15 minutes in the hallway.
If I may respond to that, our concern is that the same information could be relayed in a map that is not a satellite image, but just, a map that shows streets and locations in that way, and the location of a home could be used with a dot or a pin without outlines of houses, so that this is halfway down this block, but without the actual outlines of houses or pictures of houses, which, if you use a satellite image and you can see the roof of a house and it's the third one in, it's very easy to then determine the exact address of that house, and that's our concern. And we believe the exact same information could be relayed to the board by using a map without the outlines of houses, and then anything else in the neighborhood could also be identified as such. If there's potentially, another source of odors, which is what they raised, could be identified with another dot, another indicator on the map. And we think that using satellite imagery would not prevent or would not provide the protections that the board was concerned with about the actual addresses and specific locations of the complainants.
Ms. Brusette?
And, if I just may just add one thing, the change in the language to that second condition is kind of, so that's, I'm sorry, we're okay with that. And that's kind of leaving open this issue that we're not able to resolve. I think the does not include would cover even their scenario. And we would object to something that also would allow the quick determination. But we're leaving that issue we were not able to come to an agreement on, so to just address that specific scenario.
Ms. Brusette?
As Mr. Bruin was, where was it? I'm sorry. As respondent, I can't recall who just said it, but was presenting the Google Maps. I think it might have been you, Mr. Beck. So I was thinking exactly what Ms. Reichert just said. So can you respond as to why that's not adequate? That's not adequate.
Sure. There are things that you can see in the Google map that I think are very important for this hearing board in order to find the facts to see with their eyes. There's a water treatment plant that's the size of the entire neighborhood. There are specific neighborhood features, a place where livestock is kept outdoors, a place where they're producing oil wells, a place where there are other odor sources that we've identified in the neighborhood that are very close to certain things. If you don't show the actual imagery, people don't learn it as well, people don't pick it up as well. And we suggested, we aren't trying to make it possible for anyone to be identified. We don't want that to happen either. It's certainly not our goal. We're just trying to communicate well with the board on a question that's incredibly important to our client from the standpoint of the use of its facility. And I don't want to restrict the way I would try a case. I don't mind giving a heads up if I'm going to throw up a Google Earth image and we can have a discussion in the middle of a hearing if we need to. I said in the hallway, I don't mind if we turn off the webcast during that portion while the image is up on the screen so nobody can go save it at home if they have some way to save from their TV. I don't. But we just don't want to restrict the way we're going to try the case with a rule that says you can't do something that you would always do in every case. And I've never tried a case that involved environmental stuff where I didn't use imagery. I just haven't. It's the best possible way to communicate facts.
Why is it not possible to show those items, the manhole cover, anything else on a map other than Google?
It's not that it's not possible to, it's that the most important thing, and I'll be very frank about it because we put this together in a very detailed way for the litigation. And we had complaint records that were a different set. We had complaint records that started earlier and went up to early 2014. But by creating a map that was keyed to two sets of data, one was the complaint records, and the second was the emails sent out by the Google group, I was able to draw conclusions about what these complaints were, whether they were spontaneous or actually coaxed, that I thought was visually evident based on the mapping that we did. We're planning to do something very similar because we think it's important for this board to know not only how many of the complaints came from a small group of people who are in coordination with one another, but also just to be able to visualize where is the landfill, where is the school, and to me, you lose all the topography, which is vitally important to this case because of the Canyon landfill. You lose all of the pictures of the things that are important to visualize. And I just think it would be a mistake for me trying a case to agree in advance I'm not going to use satellite imagery. And I think there's got to be some other way to accomplish the goal that the district and the board are concerned with and that we're not opposed to in any way, shape, or form. But just to put a finer point on it, I mean, we think we're entitled to present this information. We think they are public records. We think the accommodations we're making are absolutely appropriate and we're happy to do it. But at the end of the day, we need to give our clients the best trial we can. We need to give them due process. And there's a lot at stake here. And it's, you know, it's the kind of proceeding that can be reviewed later. What we're not planning on doing, and this may help, is to take, for example, screenshots of the Google Earth picture and put that into the board's records as part of the evidence. We're not planning to do that. I'm simply trying to demonstrate. And so, you know, if we can do something that the board agrees with that will keep the world from seeing, you know, if we should zone in on a block, happy to do that. Happy to avoid putting things in the public record on paper by taking screenshots. I just don't want to agree, Mr. Chairman, that because I think it would be a bad way to try the case not to use imagery.
Ms. Prusek?
I think this is something we will need to determine as a board today because we're determining whether or not to grant or how we're ruling today on the motion to quash the subpoena which necessarily includes granting a protective order if we are to go with the way the parties are stipulating. And I think this is part and parcel of how that's going to be read, and the parties need to be prepared in advance if they're going to be using Google imagery in this way as to how this board is going to rule on it. And I think that the question that we're going to have to tackle is the issue of confidentiality and the right to confidentiality of those complainants who have given their names and addresses to the district versus the incremental benefit of having pictures versus a map. And I wonder if there can be some combination of a map showing approximately where these things are and where the complaints are coming from, and if the imagery is so important for these other sources, to have Google Maps of the sources. But I think we'll save it for deliberation, but I think it's a tough case to make that we can publicly display someone's house and publicly state where they live, essentially.
Ms. Byrd?
You mentioned that you have never tried a case where you didn't use this type of imagery. Have you ever tried a case where you were trying to prevent the certain locations from being known?
I've never had that be a consideration in our cases because, for the most part, they're in litigation. None of this is protected information legally. We're trying to protect it as an accommodation to people, even though the website of the district does say your information may be subject to subpoena. So the answer to your specific question is no, I haven't. I would be willing to do this because what I don't want to do is slow down the production of these records, our ability to digest them, our ability to prepare for hearing. I'm willing to live with a restriction that says if I intend to show any complainant's house on imagery in a way that has any possibility of someone looking at it and saying, oh, I know whose house that is, that I would give the board advance notice of that before I would ever make any offer in evidence, and that the board could then make a ruling at that time.
Just as an aside, I think you could graphically use dots, squares, rectangles, and indicate by yardage how many feet is the beginning of the landfill, how many feet to the manhole, how many feet to anything that you have in question that you wish to offer in evidence without giving away anything. I mean, a sleuth, a professional, could figure it out because they could just simply work on it, but it's too much trouble. But you would satisfy the issue of privacy. And I think that's really what you're trying to do. And I commend you for being open about this now, but there are ways of doing this. All you have to do is go to the graphics people and they can create this for you. So it will be really neutral because that's what you really want to show. You don't want to get people into trouble. You want to just get the idea expressed, the alternative to the landfill issue. Thank you.
I appreciate the offer to notify the board prior to presenting any visual that might make it easy to identify, make it possible to identify a particular residence. However, I'm having trouble understanding why the important features cannot be depicted on a map without having to use the Google Maps imagery. If I were if I need to make a decision on that, I think I would want to see an example of this imagery. And I would then ask the question, why can the important features not be identified without identifying the residents?
And let me say this, Mr. Chairman, if I could respond to both of the last comments. In fact, all the comments that I've heard. I can certainly appreciate that this is important to the members of this board as well as to the district. I think that with some advanced planning, and the only caveat I was going to give you is that when you're presenting a case, things come to you that you didn't think about yesterday or last night. They just do. But I also recognize that even if I have an advance warning requirement, I'm going to have to prepare in advance for the possibility that I may not get permission to use something. So it's on me to go create static images where I blur out houses or something that helps protect against that, and share them with the other side before I use them, so if there are any issues that we flag them. So I'm willing to accept essentially the restriction that if I use imagery, it should be, you know, pixelated or in some way altered so that you can't pick out the particular house. But I just want to be able during the hearing, if I think I need something in addition to that, to ask the board to make an exception to that. And I don't even think that requires writing anything now. I think the protective order can contain the restriction. The board certainly has control over its own hearing, and if I need to raise something, I'll just take it upon myself to raise it later. But I'm comfortable with putting in the restriction now, and I'll just do everything I can to stick with static imagery. It's not quite as easy to do on the fly, but static imagery where I do something to make it impossible to figure out exactly which house is involved. We were going to put dots in the middle of the street, which would at least narrow it down to 2 or 3 houses, but I can do better than that because I can see it's a concern to the entire board.
Thank you.
Mr. Chairman,
Senator?
could it be considered as witness intimidation? If you know where they live and they come in, they see some imagery, a map showing where they live, even though you've decided you're not going to show their addresses, but then they're going to identify where they live. You're going to know where they live, and they could be feeling like they've been intimidated.
May I answer that, Mr. Chairman? I don't think so. I mean, this is information we've had and been using and had in depositions and had throughout the litigation since it was produced by the district, just covering a different time period, and we've used it in exactly the way that I've described. But I don't think that you know what we have to do in our defense is show that a few homes made the vast supermajority of all the complaints, that those homes were communicating with each other through this Google group, that the homes were included the people who were leading the litigation for money damages. And I can't prove that without using the information in the records, which is one reason the district has agreed to produce them, and we've agreed to a protective order. You know, I would hope no one would feel intimidated simply because, you know, that their block was depicted on some picture exhibit as being the source of a home that had a bunch of complaints. I just don't think that would make people feel intimidated. And I certainly will tell you, the complaint record before the board, or at least at the district, shows that nobody's been intimidated about anything. If people have a complaint to make, they're very, very vocal about voicing it.
Mr. Beck, we've been informed once again today that that case has already been settled.
Yes, sir.
So now we're dealing with the protective order request.
We are.
And in that, we're starting a new case.
Yes.
And when it seemed like to me that if you're going to identify a cluster of individuals in a certain specific neighborhood that's complained over a period of time about the landfill being close to their home and what they smell, then they know that, you know, you're not giving the addresses because now you change your request where the addresses will not be provided. However, you know, when you learn who these people are, when their names have been redacted, have not been redacted, then of course If you know who they are, you can also look up their addresses. They're registered to vote. You can look up their addresses, even though you say you would not do that, but there's a way where you can get their addresses. And you begin to identify all these individuals, and now you'll have their addresses by other means. And then, of course, it becomes a cluster of people who have the same problem that they complain about because they live in the same neighborhood and they have the same exposure to the problem. So, you know, it's easy to obtain the information that you're saying you don't need.
Mr. Chairman, I should clarify, because what is before the board is that the district has agreed to give us the complaint records without redacting anything. They're going to give them to us with all the information included. I'm going to do analyses. If I present those analyses to the board, then the statistical analyses will use codes and will not give any names or addresses so that they won't be placed in the public record or seen by the public at large. I will know those names and addresses. I am, however, forbidden to contact them, and we accept that perfectly willingly. And I think that's a substantial accommodation. You know, it would be, sometimes it would be helpful to us to be able to call one as a witness, but we aren't going to be able to contact them at all, and we've agreed to that.
Well, in the protective order, unless I read it, unless you modified it, you said you can contact them.
No, it's in the protective order that we cannot.
Right here, it says that the names represented in the class action being maintained by the BFIC in Los Angeles County Superior Court, you can contact them,
No, sir.
who have testified at the hearing in this matter or any public hearing or town hall meeting conducted by the district regarding Sunshine Canyon landfill. And what you're saying also is that any individual who testified at any time, not just the individuals who testified at the case or part of the complainant. I'm looking at it says stipulation and protective order. You said you just.
That's not in there.
Oh, has it been changed?
Does it have a date stamp of August 31st?
I think you're reading the document from the PRA request or possibly
Okay, all
a
right.
previous matter.
So this has changed,
It has, in paragraph 3, Senator Holden, on the second page,
right?
says BFIC, that's my client, shall not initiate contact with any of the complainants identified in the unredacted complaints. So the board is going, or the district is going to produce the complaints. We'll have them. We have to keep them close. We cannot contact those people. We can only use the information for purposes of this proceeding. We have to give it back after the proceeding's over. And to the extent there's information from the complaints that we use, we mask the identity as part of our presentation of evidence.
So no depositions like you
No
had initially?
depositions, no contact.
Okay.
Ms. Brusek?
I have a question about the third new condition that is being added regarding any complainant called as a witness to testify shall be deemed to have waived nondisclosure. What does that mean, called as a witness? Does that mean called by the district as a witness, or does that mean called upon during a public hearing with a speaker card?
I think would be both. I mean, the district is envisioning contacting people who have made complaints as part of enforcement activities. And I would also like that to include if people appear on their own, not part of the group that the district intends to call, you know, with the understanding, or if the board wants to advise them, or the district could advise them that if they choose to do so, you know, like with any. Can we take a brief recess?
Yes, because, okay, yes, do that.
We'll take a 15-minute recess, reconvene at 20 after. We're back on the record.
Thank you, Mr. Chair. After Ms. Prusak's comments, I think we're no longer in agreement with that condition amongst the parties. Condition 3, mainly because under the Brown Act, although people can choose or not choose to comment or testify, they're not required to identify themselves. That language is not required, and so the district is really not in a position to waive those people's ability to do so. So the district would request, to add after the second sentence of witness by the district. Respondents are not in agreement to that, so I would bring that before the board to decide whether they want to add that condition in reaching their ruling, although the order is stipulated, so that item is no longer stipulated to by the parties.
Mr. Beck?
I'm not sure I understood the last portion of that. I understand that he wants to change the language that we agreed on by adding the phrase "by the district," which we didn't agree with, but I'm not sure I understood the last thing Mr. Sanchez said.
Yeah, so that condition is no longer stipulated to by the parties.
Okay. And so, yes, Mr. Chairman, we are in disagreement on that. If someone actually appears at the hearing, they can certainly be told in advance that if you take the stand, then people might ask you about complaints that have been produced in this case and make a decision based on that. But I don't think that the board can have the control over who is subject to cross-examination by determining which to call and which should appear at public hearings, not called by the district, but simply appearing without being called.
Ms. Prusak?
Before the Saturday hearing, I was advised by our outside counsel as to the Brown Act and what we can and cannot require of witnesses who appear before us. And as Mr. Sanchez just stated, it was reported to me that the Brown Act does not require witnesses that come before the hearing board or any public agency subject to the Brown Act to disclose their name or their address. And so I would be very loath for this hearing board to have a protective order that waives rights of people who are otherwise granted under the Brown Act those rights. I think that we can take into account, we would run into a very red area because my directions to those who were testifying on Saturday included that very instruction that their testimony may become more relevant with regard to nuisance were they to choose to disclose their location and their address, but then in fact they were not required. So having been told that, to now waive that right is absolutely not appropriate. So there's that problem, but as far as it is incumbent upon the district to prove its case. So if witnesses come and do not disclose that information, is for this hearing board to determine the relevance and the credibility of those who are appearing, and I think that's defense enough.
As I mentioned, I'm counsel for several public agencies, and I think there's a distinction between what typically happens in a public hearing, a Brown Act public hearing, and what happens in the hearings before this hearing board. Because at most city council meetings or public agency meetings, as you probably know, there's an agenda requirement that there's a period for public comment on things not on the agenda for anybody to talk about anything they want to. And then there's also a Brown Act requirement that if there's a specific agenda item, people get to speak to that specific agenda item. But what is not required under the Brown Act in most public hearings is that people take the oath. And you can just get up and say, you don't have to give your name, you can just talk, and that's fine. But in this proceedings where people are giving evidence under oath and are subject under the board rules to cross-examination, I think that's a different story. And folks who testify under oath ought to be subject to cross-examination. Because otherwise, you could imagine someone getting up and saying, well, the odors at my home are horrible, and I think we're now being told on the defense side, well, we can't say, where do you live? They might live in Arizona, we don't know. And so how do you weigh that evidence if you don't know where they live, if they start talking about odors near their home? I mean, it seems to me as defendants, we ought to have the right to say, where do you live?
I have to just say, ought to or not ought to. It was, the opinion given to me as the legal member of this board was that under the Brown Act, those things are not required. And I do understand that these are important questions for the defense, but they're equally important questions for the petitioners as well, for the district as well. And again, this board's job is also to weigh the relevance of evidence. And if someone coming to testify before us to present evidence of either a nuisance or anything else they want to testify on, but refuse to disclose where they live, then it's incumbent upon this board to take that into account in assessing relevance to that. But I don't think it overrides the right under the Brown Act to testify without giving name or address. My only other question is, what is the relevance according to the parties? Mr. Sanchez, you mentioned now we no longer have a stipulated protective order, but is that necessary for this board to have stipulation of the parties?
I mean, I would say not to that condition. I don't know if we could still reach stipulation on the other parties, and perhaps on this issue, we would take it up on a witness-by-witness basis through the hearing. I mean, as you've identified, that's ultimately what the determination is going to be. What is the relevancy and what is the credibility of the evidence if there's not a full examination of a witness by either party? So I think the district can stipulate to, everything else but that condition. If we remove that condition, hopefully we can still just be in stipulation on the protective order and then just address that issue during the hearing as it comes up.
If I may just make a brief statement, I just was looking up the rules regarding public testimony. So it's AQMD Rule 511 regarding evidence, and Section D discusses public testimony, and it does not specifically permit cross-examination under that section of public testimony. I know typically we do allow that type of cross-examination, but it says statements under this public testimony section need not conform to formal rules of evidence, nor with sections A, B, and C of this rule, which included the right to cross-examine. So just something to consider.
And there's a good point made, because it's to be considered generally when we're ruling on evidentiary matters that this board is not required to follow the rules of evidence. Just another point to be made. But we do allow cross-examination, and I think every person who chose to testify at the Saturday hearing indicated for us where they live in terms of distance, at the very least. So we could assess where they were related to the source. I don't know that particular address is important. And in particular, again, given that all of this information is being provided under this protective order, should we rule today, by the district, and the respondents have a right to take all that information and analyze it in any way and present it before this hearing board. I believe cross-examination asking for specific address is superfluous.
Mr. Bruin, Mr. Sanchez has offered a stipulation without that third additional condition.
He's offered the stipulation with the third condition with an edit to it, which would say a witness.
I offered to remove it completely if it's going to hold up the stipulation. I would just remove it.
But
and we can-
removing it would destroy the stipulation. Your edit doesn't destroy the stipulation. So the edit that Mr. Sanchez proposed to paragraph 3 is any complainant called as a witness by the district. He would insert the words "by the district" to testify. That would solve the issue with respect to people who appear in public testimony, but I will say that I respectfully disagree about what the board's rules provide, because the rules say each party shall have these rights. I'm reading from B2. Each party shall have these rights: to call and examine witnesses, to introduce exhibits, to cross-examine opposing witnesses on any matter relevant to the issues, even though that matter was not covered in the direct examination, to impeach any witness, regardless of which party first called him or her to testify, and to rebut the evidence against him or her. So I don't know that anything will ever come up that requires a ruling. If the board enters this in this form, I will simply point out that there may be times that we wish to cross-examine a witness who appears in a public hearing and is not called by the district, but I'm willing to accept having to approach the board about that topic before raising their address or the information identifying them from their complaints, and the board will then have a chance to rule on that in a specific context.
Mr. Sanchez, I thought I heard you say that if proposed additional condition number 3 is dropped, that you would be willing to stipulate. Is that what?
Well, I think if they're willing to agree to adding by the district, that addresses the district's concerns that we couldn't waive people's ability to not identify themselves under the Public Records Act. So if, as Mr. Beck indicated, if, they still have their rights under the district rules regarding evidence at the hearing, we would just ask that by the district, if that can be added to condition 3, then I think we're in agreement.
Acceptable to you, Mr. Beck?
It is. I did make my statement about what I need to do with public witnesses, and I'll take that up then, but that is acceptable. It wouldn't be acceptable without paragraph 3, Mr. Chairman, because paragraph 3 is the only thing that lets me use specific information at all. And it's limited now more than I think it should be, but it's still a way to use that information with certain witnesses, and that makes it acceptable on the whole.
I see. We've asked a lot of questions. Board members, you ready to deliberate? Looks
Mr.
like
Chairman,
Senator.
are we in the stipulated order, protective order at this point in time?
Well, what I asked is if you have any questions remaining. If not, I'm going to ask the
Well, I
parties.
do have a question relating to the stipulated
You may ask.
order. As I was stating earlier, and I have the more current order in front of me, and it says on line 25, 23, that the district shall produce to respondent, representative, all documents, electronic file, et cetera, 1 through 10, including order complaints records. That includes everybody who's ever complained.
Is this in the stipulation and
Yes.
protective order?
Right.
And what page?
It's on page 1, line 25, that I'm referring to,
Okay.
including orders, complaints, records. That's including everybody who's ever testified. And then they go on page 2, line 9, it says that this paragraph contains no limitation on respondents or their counsel cross-examining or subpoenaing as witnesses any individual identified in the unredacted complaint data. That's anybody who's ever testified before the group for any purpose. The district made a statement.
You said you had a question. What is the question?
My question is then, to Mr. Sanchez, he stated early on that they each witness, each person who testifies, or made notice of the fact it's on the, that their information would not be disclosed other than would be kept private. I think
Yeah, let me address this one more time, Senator. In evaluating producing this record, it specifically goes before a balancing test. Evidence Code 1040 and Section 6254 of the Government Code, which deals with public records. The two decisions that the district was involved in request to produce this information took on that specific balancing test. The court has consistently, or courts have consistently held when that information is requested for a defendant to defend themselves in fairness and in the interest of justice, they allow production of that information under protective order. That's exactly as we're proceeding here. And so, yes, we've represented to those people that we will protect their information to the maximum extent feasible. However, we're relying on that information to seek enforcement action and impose conditions against this facility. We can't have it both ways.
well, what you do have then, if you vote for the stipulated and protective order, what you're doing, you're allowing the respondent the information they need to examine and cross-examine the individuals whose names are listed in the complaint, the class action complaint. But you go beyond that and you say that any individual who's ever made a statement before the district that they have a record of, then they could be subpoenaed according to line 10 on page 2. They could be, although they may cross-examined or subpoenaed as witnesses. If they've ever made a statement at the district complaining about this site, they can be subpoenaed according to this order.
What the intention of the order is to limit the time and duration which we've reached agreement on, that it should only include the time frame what the district alleges as part of the.
That's clearly understood between 2013 and 2016.
Regarding condition 3, the limitation is that the information provided to them would be any individuals identified in that information. What we have before the board today is a subpoena, and so if they were to pursue any other subpoena, which I would find to be quite untimely after this, but you're basically, I think you're identifying things which is not before the board.
Now, what about line 9 where it says no limitation? Read that and explain it to me, because I do have to vote.
Right, they're subpoenaing witnesses identified in the complainant information. So this is the only subpoena that's before their board, the
And the
board.
ones that were not included in the complaint are also provided unredacted.
It says identified in the unredacted complaint data for this case.
And the unredacted data includes everyone who's testified before the district that they have a record of.
No, I think you're mixing the two subpoenas. There was another subpoena where we tried to reconcile the information requested by respondent for informations that have identified themselves. That's not the subject of this subpoena. This subpoena is solely the subject of the enforcement records for the last 3 years.
Explain lines 9 on page 2 where it says, this paragraph contains no limitation. Please explain that to me as you read it.
And so when we provide them the information, that is the basis for the district to issue NOVs as part of its enforcement action and is the subject of this order for abatement.
So it also means that any individual who's ever testified before this district regarding that landfill could be subpoenaed as a witness. And even though their names are not included as part of the complaint in the class action suit.
I think Mr. Sanchez has,
The rest of the sentence, as it applies to this administrative hearing.
These or and is and or, that's the key.
I think Mr. Sanchez has fully responded more than once, and
Let me ask Mr. Brewing a question then, sir. Would you intend or would you to ever subpoena a person to testify, provide evidence who was not a party to the complaint of the class action suit?
I'm not sure I understand the
Well,
question, but maybe a quick way to cut through this is we don't, at the present time, have any plans to subpoena any individual witnesses. If we did, because of something that happens during the hearing, decide we need to subpoena a witness, we have to present the proposed subpoena for the board for consideration, and the board at that point could determine whether or not it's appropriate to issue the subpoena based on the circumstances at that time.
So this subpoena request could include individuals who are not a party to this class action complaint?
It could include anybody, but the point is we need to have the subpoena approved by the board before it can be issued. So that's the protection I think you're concerned with having.
Well, that's
I
right.
think this question has been fully explored. I think we need to go on. You'll have an opportunity to discuss that with your fellow board members during deliberation.
Okay.
Ms. Byrd?
I believe in your opening, Mr. Sanchez, you said something about the proposed schedule had not been agreed to, and I just wanted to.
That's correct. I also addressed, I think there was some additional items in there to alert Respondents' Council that they had wanted added to it. But what Respondents' Council, following the pre-hearing order, which just the chairman was present on, we identified and he memorialized in his summary of the order the things that should be identified as part of scheduling or deadlines as part of the hearing. And so we both sort of gave our proposal for the board to review in determining the schedule. But I believe there are some additional things that respondent is seeking added to that list, but it is not a stipulated list by the parties. It is in response to the pre-hearing order issued by the chairman.
Okay, and I wasn't real clear then and I can't remember which party stated this, but that in order to not pursue the motion in limine, that we had to approve a schedule? Was that what you? Okay.
If I could comment, this schedule is agreed to so far as it goes. There were just 3 clarifications we had. One is we'd like to file an opening brief. We'd like to do that 2 business days before our case starts. The second item is we would like to have an opportunity after all public comment is in to be able to respond to any public comment, because you may hear from people who represent public agencies or whatever on items that we want to rebut. So we'd just like to make sure that we don't object to you're holding as many public hearings as you want or giving public notice to whatever radius from the landfill you think is appropriate. We just want to be able to respond to that public comment once it's closed. And that's really not discussed in this proposed schedule. And the third thing is that since we're going to be responding to the district's case, we don't know all of the evidence at this point that the district is going to be put in. The proposed schedule doesn't talk about when we need to exchange expert reports, if any. And we want the ability for our case to exchange expert reports 2 days before, 48 hours before an expert would testify, to give the district adequate time to review those reports.
Is that then not what's mentioned here, under bullet point number 1, under hearing schedule, exchange of petitioner witness, et cetera, list, 7 days?
That talks about their giving their information to us, and it talks about
But not the reverse.
proposed expert witnesses and resumes, which to me is a list of experts and their CVs, and I'm talking about reports.
Okay.
So this is actually bullet point number 3, And we don't mind if we get the district's expert reports 2 days before the district's experts testify either. It's fair for both sides, but 7 days may put a crimp in our style because they may have an expert testify at the end of their hearing, and we may not be able to get an expert report done 7 days before we want to call one of our experts. We think 2 days is reasonable.
Okay. So those two items, the opening brief 2 days before the case, the second one, opportunity after public comment to respond to public comment, and then specifics on when to exchange reports 2 days.
That's it, yes,
Okay.
thank you.
Thank you.
This, whatever schedule we adopt, I think we have to understand that it has to be flexible. There will be things that, there may be things that come up that we do not anticipate at this point. Ms. Prusak?
The 2 days, was that agreed upon by the district?
No, we wanted more time than that to review the expert reports. They expressed their concern that they might not have enough time to prepare the report if, let's say our case closes and their case starts the next day, that they may not have enough time to give us, say, 7 days lead time of the expert report. So I had suggested perhaps we could do 7 days unless, there's not some sort of a trigger based on the end of petitioner's case and or the petitioner's. Would you want it triggered potentially off of just petitioner's experts or petitioner's entire case? But I was thinking maybe we could have a trigger where it was so many days after the petitioner's expert witness testified, so that we could have more time, because we didn't think that 2 days would be sufficient for us to review.
And the reason why I asked it in the first place also was because 7 days is self-explanatory to me, because if it's a week before being presented, it's clearly a working weekday for the district. But 2 days, does that mean a Sunday when the district is closed on Monday? Or I didn't understand that.
I'd intended to say working days, 2 working days. But to answer the question, I mean, we could, if we have some time after the close of the petitioner's case to submit our expert reports, that's another way to do it. We just don't want to be in a position where we hear testimony on Wednesday and we want to call our rebuttal expert the next day and we don't have time to prepare a report. We'd rather be in a position where we can submit a report. If we have 2 days before we have to call that expert, we can get a report prepared. And
But in that scenario, you wouldn't be able to do that. If we close on Wednesday, you would have to have submitted the report at least on Tuesday to call them on Thursday,
well, we need some break in the hearing so that we could
right?
prepare reports. Otherwise, this process won't work.
We would be okay with 4 days, perhaps, 4 working days, if we could
Okay.
agree to that.
We're going to take a lunch recess.
Mr. Chairman, just one final question. Thank you. Mr. Sanchez, has there been an abatement order issued against Sunshine Canyon before?
Yes,
Yes,
I'll
there
answer
has.
that.
How many times?
Well, to answer your question, there's been one, and I believe it's been amended twice, maybe 3 times.
Was there any request made for public records in those prior hearings?
There were public records requests. I think we provided some investigative information to the parties, but those matters were stipulated.
Were they unredacted?
There wasn't any identifying complainant information provided previously.
Unredacted.
Correct.
Thank you very much.
Ms. Prusak?
I just wanted to make sure you understood what Mr. Sanchez said, that there's a difference in the previous order for abatement because it was stipulated, and under stipulated.
I understand stipulation.
Right, and so there was no need or is no burden on the district to prove the nuisance. That's different. And so the nature of the evidence that needs to be presented and defended is different, just to be clear.
Okay, we're going to take a lunch recess. I've looked at the calendars for the hearing board and expected absences of some board members, including the chair, and come up with some possible date. Sir? Came up with some possible dates for your consideration. That would be October 25, 26, 27, 3 days straight. Then the following week, November 2nd and 3rd, I've provided only 2 days that week because this board has other hearings, including emergency hearings that have to be heard, and hearings where petitioners may be facing a deadline that they may not be able to meet. So that would be November 2nd and 3rd. Then we have November 9 and 10, November 16 and 17. And if this board decides to hold a hearing on a Saturday, it would be Saturday, November 19th. So I don't have the schedules for Dr. Lerner or Senator Holden. So during the lunch recess, if you could please check your calendars, see if there is any conflict between your personal schedules. Ms. Prusek.
I could just tell you that I'm out of town on the 19th of November.
Okay.
I would just, in determining the board members' availability, Mr. Chair, I would just ask that we ask about, at least 2 Saturdays, either before the 25th and after the 27th, or before the 25th and after, or before November 2nd, because I would anticipate to try to have all of the district's complainant witnesses on the front end of the hearing. I think that would probably provide the most efficient and orderly process, and the experts and any district witnesses during the week would be better, but I think we're probably not going to get complainants to attend but for Saturdays in the community.
When you come back after lunch, there's 2 questions I would like you to address. Number 1 is, why would we need 2 Saturdays? Number 2 is, given the fact that the district now has the ability to webcast all of its hearings, and apparently there is technology where members of the public who might wish to testify can do so remotely. So we can do it 2 ways, back and forth. Why does it have to be off-site and on a Saturday? So you can respond to that after lunch. Ms. Prusek.
I also wanted to address one matter, if a respondent could respond also after lunch. And the question is, the 4 weeks that we've been told that respondent would like 4 weeks to prepare once it has received the unredacted complaints from the district. And a good portion, about a year's worth, it seems to me, has already been within. No, I see. Mr. Beck is. I understood that respondent had complaint information from the litigation up through up to 2014.
February 2014.
Okay.
There's a very slight overlap between what we have and what we need for this proceeding. A few months out of 3 years.
Okay. If you could just report to us at all, I am concerned that the first 2 weeks or so that we could be holding these hearings, the hearing board, 1 or more hearing board members are not available, whether or not it is possible to start the first week of October. So if
I will not be here the first week.
Oh,
of
you will
October.
not, I apologize. I'm speaking out of turn, so never mind.
The first week of October, I will not be here, including the first Saturday and the second Saturday and the third Saturday. Okay, that's one of the reasons I came up with this proposal for hearings and taking into consideration Ms. Prusak's availability, Ms. Byrd's availability. I did not take into consideration the senator's availability, nor Dr. Lerner's availability, because I have not received any information on that. And after the lunch, when you all propose something, perhaps,
Chairman, if I'm not available, will my alternate be sitting in for me?
that is correct.
So for those who are not available, the alternate can sit in.
That is correct.
Thank you.
For ordinary hearings, I find that acceptable. For significant matters, such as this one, I prefer that the board member that has been sitting in for considerable period of time, who is most familiar with what's going on, that we take that into consideration.
They can brief themselves by audio and
Absolutely.
and bring themselves
absolutely.
up to speed, right? That's
That
understood.
is a possibility, and if it came down to not being able to proceed, or some other compelling reason, yeah, that's what we would do.
Thank you.
What time would you like us back, Mr. Chairman?
Is 45 minutes sufficient? I'm expecting a revised,
I can't cook my lunch then. I'm kidding, I'm kidding.
I'm expecting a revised schedule. And do y'all want 1 hour? Let's do 1 o'clock. We're in recess.
Thank you.
We are back on the record. During the recess, the board has received a revised stipulation and protective order proposal, which includes the 3 additional conditions that were discussed prior to the recess. In addition, we have received a revised proposed schedule for pre-hearing deadlines and hearing schedule. Mr. Sanchez, before the board begins its deliberation, you have anything further?
Yeah, I think the parties were remiss too. We had not agreed on the issue of whether the district's custodian of records shall appear at the hearing. Rather than extending our hearing anymore today, I think the district articulated its position and its opposition. I would just add regarding the proposed schedule, I understand the chairman's, wanting to be efficient and, mindful of resources of the district, but based upon the nature and what's at stake for this proceeding, although I may not be opposed, and it's probably something we should further explore for future hearings on having people testify remotely, I would rather not try to take on that endeavor now for the first time. I think it's an appropriate thing to do, and the technology is probably there, but based upon the credibility being an issue in this case, and, the coordination necessary, I think it may be something that's not ready to pursue at this time. And so I did add some Saturday days on there for petitioner's case. They weren't days that were provided by the board, but I put that in mind with not being ready to agree or being opposed to trying to do remote hearings at this time. Thank you.
I see 3 Saturday dates. 4, where's the 4th one? Oh,
The only other thing
you
I was,
anticipate more than 1 Saturday hearing date?
I would ask for 2, just for an abundance of caution. The other thing that the parties had talked about after the break, and I don't know what the district's the board's normal procedure is, but it's something we can discuss, is whether they would be willing to have any Friday hearings. That's something that I think the parties would probably be in agreement to, but I don't know about the board or its members. I'm sure your schedules are already determined based upon, as is most of the district, for Mondays, but I don't know how that would impact your Fridays, if it's something you may be willing to consider.
Oh, I can't speak for the other board members. Inasmuch as I'm required to be available on Fridays, I do not have a problem with that, but the governing board's resolution on compensation, as well as the announcement for the positions that we all enjoy here, speak of being available 3 days a week, and on occasion, Saturday. The board has now, this year so far, conducted hearings on, I think, 9 Saturdays now. And like everyone else, board members have other things that they are committed to on weekends. And have made a number of sacrifices. There are sometimes commitments that board members just cannot get out of, or that work a substantial hardship. On the other hand, we not only understand, we want to make it possible for the public to, in a case as important as this, where public testimony is such an important part of the evidence that this board has to consider, that we facilitate that. I think that can be facilitated with one Saturday. And that Saturday will have to be carefully chosen to make sure that those board members who have sat on this matter for some time are available for that Saturday. Ms. Bird, do you have a comment?
I was just trying to remember, Mr. Sanchez, did you say that it was your intent to call witnesses on Saturday when you go to the community?
Yes, I mean, ideally, I would like I said, my colleague brought up a good point. I mean, we can, number one, I defer to the board's judgment on however they want to coordinate the schedule and respect the constraints and the guidelines in which the requirements your position puts on you. So I have no, problem with however you want to allocate the schedule. I'd like at least one Saturday, and what I'm basing on and asking 2 Saturdays, I think, is we were all there last Saturday. We got through a few witnesses by the morning session. So the issue before the board is, and the allegation is of an ongoing public nuisance. And so I just want to, for my case, to have enough time and to facilitate the attendance of those people that I think would, as argued by the district, prove those allegations that we've put in the petition. So that's why I had asked for 2 days, was just based upon the last Saturday and the amount of testimony that we put on to give enough time to accomplish that. And that's why I thought 2 Saturdays would be
So
necessary.
those 2 Saturdays would be for witnesses.
Yes.
And then you also want to have your closing. We're supposed to have deliberation in the community as well. So that would be at least 3 Saturdays.
Right. I mean, again, I defer to the board. I mean, that would be the best scenario for how we've approached these cases, but I'm willing to try to accommodate whatever schedule the board determines is reasonable. And if there's any problems with that, or as we've had in the past, locating a venue or securing a venue, I will let the board know and respondents' counsel know immediately.
I'm only asking because I know that we have other cases that we may be going out on Saturday. And so there's probably not enough Saturdays to accommodate, and I'm just trying to, we'll figure it out. We'll figure it out.
I think the way to go is to set the first few days' schedule and take this information along with the availabilities of the board members and revisit the schedule at a pre-hearing teleconference next week sometime. And at that time, I would hope that I would be able to provide to the parties a schedule that we can all live with. Senator, did you have a?
Mr. Chairman, I strongly feel that we should provide the district the best opportunity that we can in order for the district to present the people's case. We're sitting as the hearing officers, and we should be juggling in a way where we can accommodate the district. Now, other things can happen in the case we can't. But if this is the order in which the request is being made, like on the 29th or the 5th, and then perhaps on the 19th with the respondent, so be it. But it should be done. I don't think we should put them in a position where it's stall, where you wait for another day, and then, of course, the folks, he's not ready to go. That's what I think. I just think that if he wants the 25th, 26th, 27th, 29th, 2, 3, 4, 5, then it should be that. And that's what we're here for.
On 3 days a week. Ms. Prusak?
I don't know if for really having this discussion now. But if we do, I'd be happy to present my position on it. I'd much rather not, but I will if need be.
Once again, we should not tie the district's hands.
To the extent that we are able not to do that? Ms. Prusak?
I've been on this board for 7 years. I've been available. I've rarely, if ever, taken a vacation. I've been available for every Saturday hearing. I've never seen the number of Saturday hearings be as numerous as this year. And I know it's not what was contemplated when allowed for, or certainly not upon our taking these positions. I don't take issue with moving the case along. I think it needs to be. I don't take issue with accommodating the public. I think that's very important. However, I will say personally for me, it presents a hardship, and I'll say it, and in particular in the next few months, where I am a working mother who needs to take care of a child and have nobody else because my husband needs to work Saturdays in the next 3 months. And if I do not sit on a Saturday hearing, which would be fine if it were 1, but if it's 3, I do not get paid. And that presents a significant financial hardship for my family. So that's my position.
Thank you.
If it's 3, you do not what?
It presents a significant financial hardship for my family.
I should say that this year, we've had more Saturday hearings than the prior 3 years or 4 years put together.
Mr. Chairman,
I'm going to call on Ms. Byrd.
go ahead.
I just wanted to go back to the, we all want to move this along. In fact, we had planned to be available the 10th for this hearing. We cleared schedules for that, and we're not doing that. And I understand that things happen, but it is difficult to just keep your calendar open to accommodate whenever the schedule comes up. I don't think that's what we were required to do based on the resolution, which says an occasional Saturday for a case that might be of concern to the community. We've gotten so many now that are on Saturdays, and we have more coming up that are not even this case on Saturdays. So I think that there should be, I think we should all understand that we want to move it forward, but I also think that we have to make some other accommodations. And personally, I could do a Friday. If it meant I didn't have to do a Saturday, that would be much better. But I don't know if that accommodates anyone else, but I'm just hoping we get this.
Let's pursue the discussion of the dates. Ms. Prusak, is there any problem in
Mr. Chairman,
consult?
before,
Excuse me, I'm speaking at the
I
moment.
know I'm going to get your attention. And the reason why I want to get your attention is because we had a hearing on setting dates for attendance with alternates and all present. You the one who agendized it. And we had a full discussion. So we did talk about setting dates aside for hearings. We should consider that hearing where it was thoroughly discussed.
I'm going to take a 5-minute recess. I learned long ago that it's a good idea to take a time out rather than say something that might be inappropriate. So I took a time out. We're back on the record. Dr. Lerner?
I'd like to make a suggestion and sort of think out of the box to accommodate the people on the board. And what my suggestion is that Saturdays, I think, for the next 3 months are going to be very difficult, if not impossible, because we have to have the strength of the board at all times in order to give everybody a fair trial, hearing. And I'm very new to the game, and I may be a little naive, but my suggestion is, I heard in conversation just a few moments ago that we can have evening meetings out in the community, which benefits the community because they don't give up a Saturday. Of course, they give up an evening. It puts us at a disadvantage because some of us have to travel long journey trips. But we might get more things done that way. And also, the time constraint will be shorter and will be a little bit more poetic instead of literary, if you know what I mean. Please think about that suggestion, everyone. Thank you.
Ms. Prusak, well, what I was about to propose before I got interrupted a couple of times was that I meet individually with the board members or as a group prior to the next pre-hearing to see what kind of a schedule we could work out. Would that, is there a problem with doing it that way as far as noticing?
I can't
public or whatever?
imagine, we're not discussing the outcome of any case or anything that would have to do with the outcome of any case, merely scheduling.
Okay.
Yeah, I mean, I would just talk to your counsel. It sounds like it may be like a serial meetings.
I do, but it is, but I wonder if it's,
Right.
if it's something as banal as scheduling.
Yeah, I mean, I don't know, but I think we've identified the same thing. I don't know what the,
I appreciate that. So why don't we set the schedule, Chairman, for the first week of doing it, and then I can have a discussion with outside counsel, and then we could determine whether we need to further discuss schedule on the record, or we can do so off.
Okay, I think that's the way to do it, is to set the first few days, and then between now and then decide what would be in the best interest of all concerned. Okay, if there's nothing further from the parties, I think the board is ready to deliberate on the questions before it.
Mr. Chairman, may I just
Mr. Brewer?
comment briefly, just to help shorten things up? With respect to the stipulation and protective order, I just wanted to let you know that we're fine with the revised stipulation and protective order that's been presented to you by the district's council. The same is true for the proposed schedule, except for the very last bullet point, because it's inconsistent. Well, what it says is public testimony and board deliberation on the last day of the hearing. It's inconsistent with a couple of things, which is we want to have the opportunity, which is also provided in the schedule, to respond to public comment. And there's also we have to make provision for closing briefs and oral argument. And so my suggestion is that we not have a public comment hearing on the very last day after we've already argued the case and we've closed the evidentiary record, because we have no ability to respond. And this is a gratuitous comment on my part, but the board might want to consider, if you're not doing public testimony on the very last day, of not doing it on a Saturday in the community, but doing your deliberations here and having it webcast. With respect to the dates that you gave us, they're all fine from the respondent standpoint. And with respect to the custodian of records, we don't know if we're going to want to call the custodian of records at this point. It depends on the production of documents and on the testimony of witnesses. So my suggestion is, rather than trying to rule on that today in a vacuum, you wait and see if we renew that request, and if we do, then you can take it up at that time.
Thank you.
There are 3 items in the subpoena that I think we've already discussed and the board needs to rule on, which is items 21, 22, and 23.
Thank you. Mr. Sanchez, did you wish to add anything?
No, I think the district has raised its argument in his opening statement. I would just ask if there's any evidentiary question that my opening statement be received as evidence by this board. If we can just get a ruling on that, then I think I'm ready to submit.
Okay. I think Mr. Bruin has a question regarding your last comment.
Is Mr. Sanchez asking that his opening statement be considered as evidence?
That's what I heard.
Normally, in a civil case, opening statements are not evidence. They're just what you hope to prove by the evidence, but they're not then in and of themselves evidence. Neither Mr. Sanchez and I were sworn, so it's really not testimony.
That's right.
Just argument then, that it just be submitted as argument. I think I covered all the issues in my opening statement. Thank you.
Thank you. Okay, board members, we're in deliberation now. Perhaps we take the items one at a time. First one being the stipulation and protective order. Ms. Brusette.
I'm happy to start deliberations on this. I think this all has to do with the main, from what we understand to be the main point of the subpoena originally, which is that the respondent wanted to have the same information as the district in terms of the number of complaints, who's making those complaints, and where they are relative to the facility and other potential sources. And I think that in this particular case, it is important, as other courts have found, to make that balance between the right of confidentiality, and if you don't protect the right of confidentiality, a number of things occur, including the potential to chill people's desire to want to make complaints in the future, which inhibits the ability of the district to enforce rules such as nuisance and for people to get relief. And to balance that versus a case like this where the district must make its case, and the case is based almost entirely upon those who have made complaints, but added to that the verification of that by district inspector, et cetera, and the right of the respondents to adequately defend against all allegations and all evidence presented against their position. And I feel that with the changes that have been made and everything that I've read about the decisions of the courts that have ruled on this, and concerning due process of the respondents, but also the rights of those who are complaining, I believe that this protective order and stipulation of the parties strikes a very good balance, and I would be in favor of allowing the subpoena to move forward under this protective order, those items that relate to it.
Other thoughts? Ms. Byrd?
I'm happy to see that the parties could come to the stipulation, and as Ms. Brusack said, it will cover those who it was intended to cover by not releasing their personal information, and it will also help to move this case along.
Senator?
Mr. Chairman, members, the way I see this, that if this order is granted, it would in fact have a chilling effect on individuals who more likely would file complaints or complain about a problem as it relates to Sunshine Canyon. The order provides undocumented information about the individuals who at any time who have registered a complaint, not in the class action suit, but just complain about a problem associated with Sunshine Canyon. And even though they will not be subpoenaed unless approved by the board, they will be aware of the fact that such requests have been made. So you can't, nothing secret in politics, in law, and they'll be aware of it. And then, of course, from that point forward, people would not be likely to come to file a complaint, to register a complaint, even though they're not going to file a lawsuit. Just talk about how their lifestyle has been adversely affected by odors emanating, or allegedly odors being emanated from Sunshine Canyon. I recall, Mr. Chairman, for your information and members, there's a senator named Senator Alquist, who's my seatmate, introduced the legislation associated with the claims such as the ones that's before us. And that claim, what that lawsuit does, what that legislation did, and has now become case law, that you cannot harass, intimidate, or retaliate against individuals who file class action suits in cases such as this. In my view, one of the members who maybe weren't there at the time, perceived this action to be one of retaliation and is designed to impose a chilling effect in a way where people will not complain in the future. This company, Sunshine Canyon, has had abatement orders issued before, 3, I think you said. And during those orders, there was a stipulated agreement. The findings or the recommendation to be adhered to in this order does not differ substantially, as I've been informed, from the previous abatement orders. So therefore, what does the fact mean? It means, in my view, that we've had enough of you guys out there making complaints about our company, Sunshine Canyon. And it becomes a chilling effect where if you do it again, we have access to your information. And what it amounts to, could amount to, in my view, will amount to, if it's adopted, to say no more, enough is enough. And they would be more, not more likely, but more unlikely to complain in the future as they have in the past. And so for that reason, Mr. Chairman and members, as a public member, speaking on behalf of the public who are not here to speak for themselves, this is something that I cannot support.
Thank you. Appreciate your comments. Ms. Brusek?
Well, first of all, I just wanted to point out that public members just simply means those who don't have a particular required expertise for the 3 members that do require either legal or engineering or medical background, and that we are all in the public interest on this board. But I didn't understand the very last point, Senator, that you made about the previous order for abatement that was stipulated and the modifications. Did you say that this is not different from those?
No.
Oh, okay. I thought that's what you said, that the order for abatement sought here was no different than the order that was in effect before.
Well, I've not been informed, and I'm available to be informed, if the stipulated complaint did or did not include what the complaints made here in terms of being a nuisance. Was it a nuisance then, or is it a nuisance now? Is it different? Somebody should explain it to me, then it'll help me make up my mind.
There's 2 significant differences between the order sought here and the order that was in effect. One was what we were talking about before, which is the other order was stipulated, which meant it was agreement of the parties and no nuisance had to be proven. So there was no burden on the district to prove And so there was no need for respondents to defend. The other significant difference, the reason why this is not an agreed upon or stipulated order for abatement, is that the district is requesting a reduction in the amount of tonnage that is allowed to pass through the facility. So it is significantly different in those ways. And that is why, my understanding of why we are here with regards to this subpoena and the discussion over the need for information to be both presented by the district through witnesses and defended by the respondent.
My statement and concern is whether or not the complaints are different today from the complaints when the first order of abatement was issued, even though they were stipulated to in terms of a settlement agreement.
Well, it's a different time period.
Well, then there's only difference is only by a time, but this complaint basically is the same. I mean, the people who were complaining had the same complaint, basically. It's a nuisance.
Well, that's what we're here to hear, I think. But what we're deciding upon now, we need to decide in advance what respondents will have access to in order to prepare their case when we do hear those witnesses. I think I just wanted to respond just generally regarding intimidation, et cetera. What I'm reading in what we are determining whether to grant or approve, which is the protective order, and thus to allow for the unredacted complaint logs to be turned over to respondents, are these conditions would not allow use of the names or addresses by respondents beyond this particular hearing. And in fact, it calls for the destruction of that information after this hearing is over, and again, does not allow initiation of contact by respondents. So I think it's as protective as can possibly be, in addition to the fact we've now added provisions to ensure that, given the public nature of these hearings, no one else will have access to that information unless the person chooses to become an affirmative witness for the district and to help the district to make its case, in which case it is only fair due process that the respondents have an opportunity to cross-examine fully that witness.
I understand. You're right, made a good point. Unless and until they agreed to become an affirmative witness at the hearing, fine. In those cases where they have not agreed to become an affirmative witness, the respondent would have access to information and can request that they do in fact appear, even to this, before this board, even though they're not an affirmative witness. They can, according to the stipulation agreement.
Again, there would be no subpoenas by representation of respondents without coming before this board, nor could there be.
I understand.
Right, any subpoenas would have to go through the board to determine. So a witness cannot be called, and this, we made sure the stipulation would not waive any rights of a person who chooses to come before this board simply to give public testimony on their own accord, which I think is an important additional safeguard.
I'd like to underscore something Ms. Prusak said. Having to do with speaking on behalf of the public, public members on this board historically for the last 30 or so years have been chosen because they have a certain degree of understanding with respect to air pollution, not as representatives of the public, but rather unbiased administrative law judges who judge each case on its merits, and not necessarily representing either the district or the respondent or the public but to look at each case and decide it on the facts and the law. With respect to the stipulation and protective order, I support the stipulation and protective order. Any other comments? Ms. Brissette?
I just wanted to make one more comment, just because I want to make sure that any members of the public who were complainants or just who are hearing this will know about what we're talking, or will know about our ruling today, that this is important for, this protective order is important for this case. I believe it to be important for this case to proceed. Again, for the district to make its case, they need to present as witnesses and also just as information to this board, the complaints and the importance of those complaints and the information about those complaints to this board for us to be able to make a determination as to whether a nuisance has been proven. So given that, and given the importance of those complaints, I would assume that complainants would want their information to be part of the causation of this lawsuit. But if we do that and we allow that, due process absolutely requires that the respondents have, in some way or form, equal information in order to defend. And so if we did not grant this protective order, I would have a very hard time allowing the district to present its case as it needs to present its case, because I would think that there would be an inequality in due process.
Mr. Chairman, I could support this order if on paragraph 9 of the order, if it were deleted, that contains no limitation. It says right here.
Chairman, Cameron, can we mark this? Because we're dealing with so many different versions.
Well, this is the final version we just got after lunch.
Where do you see paragraph 9?
It's on page 2, line 9.
Oh, line 9.
Yeah, line 9. I'm sorry, line 9.
And, thank you.
Been here too long today. If they say it contains no limitation on respondents or their counsel cross-examining or subpoenaing as witnesses any individual. Now, these are individuals who have not claimed themselves to be part of the action. Now, any individual, that's really open, and I just can't accept that. If they were not there, with just those individuals who part of the case or willing to step forward and so on, I could support it, but any individual is just too broad, and then the tantamount to could be, cause a chilling effect or has harassment, as Alquist did not want to happen.
Ms. Byrd?
I'm really not sure. I'm trying to follow what you're saying. The paragraph has to be taken in its entirety, and every time you take that part, it sounds different than if you took it in its entirety. The entirety says that they cannot initiate contact. That's what the first thing it says. And then subsequently, it talks about if they are in this data, the unredacted complaint data, they might be used for the purpose of this hearing and this hearing only.
No.
So just taking part of it, I don't think really gives the whole picture.
Then you start reading from, I'm sorry, go ahead.
Ms. Byrd is talking.
Shh, yes, I heard you.
I still don't, I don't think you're taking, and this is my opinion, it doesn't appear to me that you're taking the entire paragraph in its entirety. And if it were taken in its entirety and that sentence or that phrase that you keep referring to were taken in the context of the entire paragraph, I don't think it would be considered as much of a problem. But if you take one piece of it, it might sound a different way.
Okay, then you can go look at line 7, Mr. Chairman, and Ms. Byrd. It says that PFIC shall not initiate contact with any of the complainants identified in the unredacted complaints regarding their unredacted, et cetera.
No, don't do the et cetera there. That's the important part there.
Well,
Don't miss that part.
Data, absence, and order of the hearing of or a board reviewing the court, or as the case may be,
Okay.
provided, however, this paragraph contains no limitation. And that's, when you put it all together, you're right. No limitation for people who are not choosing to be involved in this action.
I disagree, and I think that's just going to be a point of
I
disagreement.
think we're not going to get a unanimous vote on this. Ms. Prusek, did you wish to speak?
I just wanted to remind that there is the limitation on the subpoena, which is the only active way in this paragraph in which respondent can call upon a witness or a complainant. And again, that subpoena, any subpoena would need to come before this board. So there is no mechanism here to harass or otherwise contact any individual on their own initiative. So I just wanted to point that out again.
Dr. Lerner?
I've been puzzled by that paragraph 3, the last sentence that the senator has pointed out. And the question I have is, again, naive, what happens if you just end the paragraph after the word "be" and omit that next sentence? What does it change, and what objections would the respondents and the district have to that? And you, Julie, because you're our attorney, and maybe you can help me out with it. Thank you.
My understanding is if we were to take that last part out, that would take away respondents' opportunity to, should they decide to, which Mr. Bruin, I believe, represented at this moment, they don't have any plans to, but should they decide after reviewing all of the documentation regarding complaints and hearing other testimony or seeing other evidence, decide to want to hear from one of the complainants, they would have no mechanism to do that. So they would have no right even to try and subpoena a particular person.
May I say this? If there are not going to be many of these, could they just be brought up to us and we will weigh that judgment? In other words, that would satisfy everybody. Sure would. We would be able to take a look at what you really are going for, and we would be able to make the judgment, and we could get this paragraph, and we could omit this paragraph and just this part of the paragraph, just revise it to say that these requests have to be brought before the hearing board, and we can make a judgment quickly and efficiently about this.
Senator, it sounds like you're in agreement with that.
I would agree with that, because if you're going to come back to the board to subpoena someone, come back to the board to make that simple request, since it would not always apply. I see nothing wrong with it, then it's okay.
Do we still have a stipulation, Mr. Sanchez?
Well, I can only speak for myself. I mean, I think Julie, Ms. Prusak's deliberation on this matter indicated the ability for fairness and due process. I think that's what that paragraph contains. Obviously, the respondent would still have the ability to utilize the subpoena power and cross-examine anybody that the district would call as a witness. So I think if you strike after B, there are still procedural things in effect. The question would be is how would that play out in timing of the proceedings? If every time someone were to come up, could the respondent rely on the records that it received unredacted, or would they need to seek further examination or need additional time based upon people not coming up? But ultimately, the burden's on the district, so they would have to react to whatever evidence is presented by the district. So, I mean, I could live with removing that, just with the understanding that it could provide timing and delay issues in the proceedings.
Mr. Bruin?
Mr. Chairman, Dr. Lerner's suggestion was putting a paragraph after the phrase "as the case may be," putting a period, excuse me, after the phrase "as the case may be." That would be acceptable so long as we have an understanding on the record today that this paragraph 3, as so revised, doesn't limit our right to cross-examine witnesses or seek an order of the hearing board to issue a subpoena if, after reviewing the complaint data or hearing other evidence during these hearings, we make the decision that there is someone we want to subpoena. But again, a subpoena can't issue unless this board approves it. So that amendment would be acceptable with that understanding.
Ms. Bruzak?
Yeah, I'm not sure I understand why it was necessary to have cross-examining in there, because that's not initiating contact. And so I don't see that there would be any effect as far as using the unredacted information, which would include addresses, et cetera. That's something that's dealt with in other paragraphs and other conditions.
We're back to further deliberation.
Mr. Chairman, they did stipulate to that change.
Yes.
Okay.
I'll entertain a motion. Ms. Bruzak?
Maybe we should wait on the motion, because this protective order is part of our ruling on the motion to quash, and specific, well, I wouldn't think about what the motion would be, because there are other items, well, there's items 21 through 23, which we need to talk about as well. But also, there were agreed upon limitations, stipulated limitations in terms of time period on other portions of the subpoena. So I'm trying to determine what would be the best way to go about this motion, maybe if we make it all at once.
Initially, I was thinking we'd take them separately, but since they're somewhat interwoven, perhaps as one bundle.
If we all seem to have agreement that maybe we could all just kind of poll each other with that change. Is there agreement with regard to the protective order and stipulation? I don't know if you wanted to go that route and then move on.
There is, I think, we do have that agreement. Dr. Lerner?
Going to try again. I don't know if it's appropriate to make a motion that we omit the sentence after the letter, after the word "be," period, the provided that through the end of that long sentence should be omitted. I think that would be the best interest. It may take us a little longer, but remember, this has been going on for a long time, and just being a little bit more patient and being more thoughtful may have a great dividend for all of us concerned. And also lower the temperature of the board. You can.
Ms. Bruzak?
Perhaps it would be helpful.
That comment, you just won't have to take a break.
Perhaps it would be helpful if we could ask the parties, now that they've reached agreement on every item in the subpoena, with the exception of 21 through 23, if the items in the subpoena could be withdrawn, subject to the stipulation that the parties have agreed upon with regard to each of the items, the period of time for each of the items, and this board could adopt the protective order and stipulation by motion, and then we could limit the motion that we'd have to make and the subpoena that remains to 21 through 23. I don't know if that makes sense.
I don't think we were exactly in agreement on the last 3 years. I think respondent wanted some additional timeframes beyond those 3 years for some of the items.
Mr. Bruin?
The stipulation and protective order only deals with the complaint data, not the other items in the subpoena. We've reached agreement on those items. Ms. Prusick asked, would we withdraw the subpoena as to those items based on the district stipulation to produce those records? To me, it's 6-1, half dozen of the other. We have an agreement they're going to produce those records, so I'm happy to withdraw the subpoena as to items 1 through 10 based on the district stipulation that it will produce those records to us next week. And with that, then I think you can act on the stipulation protective order independent of the rest of the subpoena.
Then I'm happy to make a motion if the chairman so desires. Okay. In the matter of South Coast Air Quality Management District versus Browning Ferris Industries of California, Inc., case number 3448-14, I move that we adopt the stipulation and protective order. Sorry, did we mark it?
We did not mark it. Number 1? So we're at the beginning. Mark that as exhibit number 1. And to be clear, that is the revised stipulation and protective order that we most recently received.
And that will be with regard to all records concerning complainants.
I'm looking for a second.
I'll second.
It's been seconded. Discussion on the motion. Dr. Lerner, how do you vote? Do you want to discuss the motion?
I'm still not sure if we're taking out that last.
I'm so sorry. Let me make that change as part of my motion with the following change. On page 2, line 9, there be a period placed after "as the case may be," and the rest of paragraph 3 is deleted.
Okay. And that's what you were,
Thank you, I second the motion.
okay. Discussion on the motion as amended. Ms. Byrd, how do you vote?
I thought I had seconded it, but I'll say yes.
It was changed. Senator?
Aye, Holden.
And I vote yes, motion passes 5-0. Okay, now,
I
He
voted for it.
seconded.
I think I voted for
He's-
it. He seconded, so I voted for it. Yeah,
it was revised,
yes,
and on revision, you seconded it.
yes, so that means I voted for it.
As amended.
Thank you.
As amended.
After the amendment.
As amended.
Yeah, as amended, yes. And that's why I asked Ms. Byrd for her vote.
Thank you.
Okay,
Where's that amendment here?
let's go on. You want to tackle 21 to 23 next?
Yeah.
Yeah,
Can somebody help me out? Where is it? I'm lost. Is this one? Yeah.
okay, you can look at the subpoena request for, where is it? There's also an outline of the requests in the declaration of Mr. Bruin in support of the issuance of the subpoena and subpoena ducis tecum to custodian of records. And in it, there is the
I got it.
repeat of the requests 1 through 30, plus the, some indication of the relevance and the requested documents. So 21 is the request for all communications between the district and Larry Israel regarding notices of violation issued by Mr. Israel pertaining to the Sunshine Canyon landfill. And I think the parties agreed to limit the time to June 21, 2012 to the present. Am I correct, Mr. Bruin?
I think I said January 1, 2012 was what was in our,
January. January 21.
correct.
Mr. Sanchez?
I would just ask the timeframe for the petition, which is July 21, let me clarify. I would commit to the timeframe in which any NOV was issued between July 12th, I believe, 2013 through, October 13th, 2013 through July, is it 21st or 12th, 2016?
Mr. Chairman, we'll accept that.
Okay, so that would be October, what was that, the 31st?
13th.
13, 2013 through July 12,
July 12th.
2016.
Yes.
Okay. 10, 13, 13, 7, 12, 16. Discussion on that? The parties appear to have come to agreement on that. Want to go on to the next one? Next one is number 22. All phone records showing records of telephone communications between Larry Israel and persons making odor complaints pertaining to the Sunshine Canyon landfill. And again, we had a time, I think a time limit. Was that the same time as on 21?
Mr. Chairman, if I may respond, it's different, but we'll agree to the same time limit as 21.
Mr. Sanchez?
I would oppose that, as any communications reflected in the enforcement actions related to the time frame in question would be noted in the enforcement records provided in the unredacted information.
So, Senator?
Right, I thought I heard Mr. Bruin state earlier in the discussions that he would not request that item be delivered yet, that he would wait until some later time when he thought it was needed, and then he would make the official request. I think that was a statement that was made by you earlier, as it relates to Mr. Israel.
No, I don't believe so, Senator. I mean, the thing is that we don't think all of those conversations are going to be reflected in the NOV records. And I think Mr. Israel is probably going to be the first witness called by the district in this case, and we want that information to be able to prepare a cross-examination.
You didn't make such a statement early on?
You're asking if I made a statement earlier
Regarding
saying,
Mr. Israel, that you would withdraw the,
I might have been talking about the
request
custodian of records, saying
Right.
that we didn't need to have a ruling on that today because we don't know that we'll be calling the custodian. I wasn't referring to Mr. Israel.
Mr. Israel is not the custodian of record.
I know, okay. Although his record's gonna be included.
Mr. Sanchez, can you give me an example of the difference between all phone records showing records of telephone communications between Mr. Israel and persons making odor complaints and the records that you contemplate producing?
Yes, Mr. Chairman. I don't believe the complainants or Mr. Israel, let me back up. I believe the process is such that if a complaint online or over the 1-800-CUT-SMOG line comes into the district, then it is recorded by the radio dispatch team to the inspector assigned to that area. And so if the inspector who pursues that enforcement action or to verify an odor, the process that he or she goes through to communicate with the complainant and any conversations that they have with that complainant is to be reflected in the investigative report. And so that information would summarize those communications and the communications that are required for that contact to be made and for that odor verification to occur. So to spend time and resources to track down phone records, which may or may not be articulated in the complainant statements, which are being provided, is unnecessary and burdensome. The final determination and whether an odor complaint is verified and whether it results in an odor nuisance is reflected in the report. The preliminary things that go through gathering that information, I don't believe are relevant. And any cross-examination on whether Larry has any bias or any relationships with members of the community can be ascertained on cross-examination.
Well, obviously, I can't say what's in these records because we haven't seen any of them. Phone bills ought to be a matter of public record. They're just bills that are paid by the district. To the extent that there are summaries or other documents which exist, which are not going to be produced to us as part of the complaint records that reflect the content of telephone communications or text messages between Mr. Israel and complainants, that's what we're asking for. We're not asking the district to create records they don't have, but we don't think it would be an undue burden on the district to produce that information. It ought to frankly be in their complaint files. We don't know. But again, going through 3 years' worth of phone bills, they get a phone bill every month for his cell phone. Give us a copy of the phone bills. If there's any other record of the contents of communications that's not in a specific NOV document, we'd like to see that. We think it's obviously relevant to the case.
Ms. Prusat?
Well, I'm not sure I see a high degree of relevance with regard to phone bills, because phone bills merely show if contact was made, but not content of what was discussed. And I don't know what that would tell us in terms of nuisance, bias, or anything that would be of relevance to this nuisance proceeding. But it does seem somewhat burdensome. If it's content, and the fear is that there's content of communications expressed somewhere other than in the investigation logs or papers that are otherwise being handed over, I think I might feel differently about relevance in that case.
I'm on the border on that one. Ms. Byrd?
Yeah, I'm on the fence with that one too. Because am I understanding that I understand that you want to know the communication that occurred back and forth. Are we just trying to get numbers? I mean, what is the significance of knowing that that number was called?
Well, we're going to assemble data that's going to show the timing of when complaints were called in, and we want to see the timing of phone calls between Mr. Israel and complainants, as well as how long those phone calls lasted, and put it together with other evidence, including perhaps evidence of the content of those phone calls, because we want to see what the back and forth was between Mr. Israel and people who were complaining. The relevance of these records is that it's communications between the district's inspector and people who are complaining, which is what the case is about. So we think it's quite relevant. how probative it's going to be, we can't really say for sure until we see the evidence. Maybe he wrote down notes on his phone calls with people in a notebook, and we'd like to see the notebook if there is one, in addition to just the phone bills, which would show the timing of calls. So, again, we think this evidence could be, it's certainly relevant, and it could be highly probative depending on what the records show.
And I think notes of phone calls made might be relevant if he had taken notes, but I'm still not sure how just knowing that a call was made or not made, or when it was made, is critical to determining the content of what occurred.
Ms. Prusak?
Yes, I do think that the nature of how it's being sought to be used to show some type of relationship outside of the role of inspector would be extremely speculative, based merely on the existence of a phone call. And one could imagine an inspector not knowing where to go, or, calling to confirm an address. I don't know that there's enough probative value merely to the existence of calls or how long they are, as opposed to content, which, if that's what's being requested here, I don't think I would object to requiring or not quashing any subpoena with regard to to any written down content or record of content of a discussion that is not otherwise produced according to the records.
Mr. Chairman.
Senator?
Mr. Bruin, I get the feeling here that one could suspect that there's a conspiracy may have occurred between our employee and people who file complaints. I personally don't see any reason why you should have those documents in total. I would agree, however, that you should receive the documents where a complaint was made and then the order was verified and a notice of violation was issued. Any documentation, telephone conversation surrounding that combined events, then you might want to take a look at it. Other than that, I do know or believe that some people file a call to complain. It may be there at the time, the order, when they complain, when they get there, it's not there. So you don't see, there's no violation. And to speculate or suggest or infer or cause to, or me to receive it as such, that there's a relationship or conspiracy between those who file, make complaints and one of our employees is troubling to me.
I'll correct
I'm just saying, it's to me.
Senator, when you spoke twice about our employee, who are you referring to?
Or the district employees.
That's right.
Oh, not this board employee, the district,
Well, Senator, if I could respond, I think you make a point that obviously the most relevant information is the timing of phone calls on the days or evenings when NOVs were issued. But it would be a far greater burden on the Air District to try to go through phone bills and pick those dates out rather than just give us the monthly phone records, which is, so if we can get the monthly phone records and the transcription of the contents of any phone calls, then that satisfies our request.
I was just thinking, repeat that, sir, I'm sorry.
If we could get the monthly phone bills and the transcription of any communications with complainants by phone that Mr. Israel has copied into a logbook or a notebook or anything like that, that would satisfy our request.
Ms. Byrd?
If it were limited to notes in a log, I think for telephone records, I think that might be, I can accept that better than just the entire phone records, because they really don't indicate, as Ms. Prusak said, It could be they didn't know where they were going and they made a phone call to find out. So I think that if there were notes taken, and I think that district inspectors do that for phone calls, that I could see limiting the request to those notes of phone records.
Is that limitation acceptable?
Well, it would be acceptable if we have the ability, upon cross-examining Mr. Israel, to ask for the board to reconsider our request for the phone records, then that would be acceptable. So we'd make a subsequent request and make a showing of relevancy at that time.
Ms. Prusak?
I mean, right now, we're being called upon to act upon the motion to quash. And I'm, at this moment, I'd like to make, I would be ready to make a motion to quash as far as the production of phone records are concerned, but to not quash as far as written records of the contents of any telephone conversations that are not otherwise included in the investigation notes.
They're otherwise what?
Are not included in the investigation notes, which are already being turned over.
Mr. Chairman. Mr. Sanchez, you want to comment?
I mean, the whole point of what we've been trying to do today is to narrow down the production and to reduce the items to produce. What the board's contemplating, which I don't know is different from what the request is, or maybe it can be considered within that request, is to require the inspector, if he even retains his notes, most inspectors, I believe, are instructed to, after generating, relying on those notes to generate a final report, to destroy those notes as part of the ordinary course of business. But if anything exists, I have to go back, number one, to assume that everything is solely limited to his investigation of Sunshine Canyon landfill is very presumptive. So to have to go back through records for over 3 years to try to ascertain what specific of those records may be related to Sunshine Canyon phone calls, when the investigative report would require any identifying information that the complainant provides, and the inspector's contact or Mr. Israel's contact with that person, I think it provides the information that's responsive to item 22. I think, as Ms. Prusak has indicated, to sort of ask for information beyond that based upon speculation that's available to be ascertained through cross-examination, as I suspect it will be, in determining whether, if there's any patterns or repetitiveness. Respondents' Counsel has told this board on numerous times today that there's a Google tree and there's a group of people, so they already know what they're looking for. So why they need phone records or records of phone calls when they've already identified, I believe, the people they have in mind who they're asserting are manipulating the system, I don't see how additional data that's going to require the district to go through additional examination to try to meet the deadlines to keep this case going forward is not relevant and too speculative at this time.
Mr. Sanchez is convincing.
Well, I would like to respond very briefly. If Mr. Israel keeps a notebook of information regarding his inspections, including phone calls between him and the complainants that would reflect what they're telling him about odors, that's very relevant to this proceeding. If he's thrown the notebooks away, then that's the answer. They don't exist. They can't be produced pursuant to the subpoena. If they do exist, it seems to me we should be entitled to see them, not just his final report, because his notes might contain information that he decided not to put in his final report, such as the odor was very faint, it only lasted for 2 seconds. I mean, who knows? But it's very relevant to this case as to what complainants told him about odors that they believed were from the landfill.
Mr. Chairman. Mr. Chairman. Based on what I'm just hearing, listening to, it's Mr. Sanchez will be made available to use the witness. Is that correct? not Mr. Sanchez, Mr. Israel.
I'm sorry, could
Mr. Israel will be made available to you as a witness. He's the inspector, Mr. Israel.
he will be, yes.
Right. And it seemed to me at that time, based on the fact they don't keep these records for life, you can ask him, he'll be available to you to ask him any question regarding what he has, what he does, and how he does it. And if he tells you that, yes, I can document A, B, C, D, and I have it available, and you can request it at that time, I think that to put the cart before the horse in this case would be unusual and unacceptable.
Well, if I could respond, that actually what typically happens in a civil case is you get those documents before you have to cross-examine a witness, because if you ask Mr. Israel about a conversation he had 3 years ago, he's very likely to say, I don't remember. But if you have his notebook that describes the conversation, then you can show him the notebook and say, does this refresh your recollection regarding the conversation? Or if it doesn't, you can have him confirm that those were his contemporaneous notes. To have to wait until after his cross-examination to get the records is only going to mean we're going to have to review the records and then call him back as a witness later on. It's a further delay in the hearing. It's inefficient. Again, it seems to me whatever phone records might exist that still exist, they ought to be produced because they're very relevant to what people told him about the landfill.
As Mr. Sanchez has already stated, the standard practice and procedure are that the records may be kept for a short period of time, and then they not be required to be kept for 6 months, a year, 2 years, or 3 years. That you could learn during discovery. You can discover you can learn at that particular time how long they kept and for whatever period of time they are, and to whom they had the communication with.
Well, we can learn it through discovery, which is what the subpoena is.
I understand.
It's a way of trying to get the records.
On the witness stand.
Dr. Lerner,
Try to make another compromise. Would you just simply accept written records?
Mike,
Sorry. Would you just simply accept written records and forget about the phone calls? Because I can tell you, if somebody is choking and it's wheezing and sneezing and has runny eyes because of a bad odor, it's only going to take 2 minutes for Mr. Israel or any other competent inspector to say, I'll be out there ASAP. You don't have to have a long phone call to show that, you can look at the time of the phone call and the date. So I think timing and frequency of phone calls is irrelevant. I think the written notes may be very useful, and I think it's legitimate. And I think it also gets the burden of spending a lot of time, your people's time, and the district's time. So I think everybody benefits. You get hard written notes be the best thing. So my recommendation, I can't create a motion because I'm a doctor, but is omit all phone records, just written records, written documentation, including the NOV, obviously. Okay? If you're going to tell me that if you were on a fishing expedition and you wanted to find out how many phone calls were done, how many times he inspected, what the percentage was, that's a whole different issue, but that's not what you're talking about. You want to find out what he did. This is how you find out. If he has a written record, so be it. He may have it for some people out there, but not with others. Anyway, I think you understand what I mean. Thank you.
If you're talking about written records of phone calls that would record the content of those phone calls, then that would be acceptable.
Not necessarily. Any kind of notation that he made with
Absolutely, that's covered in other requests, but certainly.
Yeah, I just want to get the phone call business out of the way, because I think I think that's a fishing expedition that, you're gonna wind up with a lot of dead fish.
Sold.
Ms. Preside? Oh, Ms. Byrd.
I just wanted to go back to Mr. Sanchez and this, I was an inspector once upon a time, not at this district, but are you saying that there are no notes in a file specific to this case, and that or are you saying you actually would have to go back through all the notes to pull out notes for this case?
I may not be articulating how each identical file is provided, but what is generated and what my office relies upon to pursue a nuisance action or a nuisance action in this case, it includes transmittal information, some of which is confidential or between the department and the legal office. It then includes the ticket or the pink sheet, I think as this board is familiar with, that's issued to the facility. And then it includes background information to the facility, their ID number, their equipment, whether they've had enforcement history. And then it includes an assessment of the case by the inspector or the assigning attorney. Following that, it includes the notes of the inspector and what they observed, the time they went, the time they responded to the matter, and there may be additional complainants who were dispatched or alerted to the inspector as far as odor complaints coming in, and then those people's information, I think it's called the DA form, on their name, their contact information, what time they called, and the information that they reported either through the inspector and or the complaint line or online is part of that. So their contact information should be in there. If it's a online complaint, I imagine their email's on there. If it's a phone complaint, I imagine their phone number is on there. And then their inspector's interactions and the notes that they make in verifying the odor, taking measurements, all that will be included in there. As far as any notes that the inspector may have gathered in reaching their findings or recommendations, that would not be in there. It is only a packet, so to speak, with attachments that is provided to the general counsel's office to rely upon. So individual notes, no, it's not included in there. It's the culmination of the investigative effort that the inspector or the enforcement office in making a determination whether a basis for an enforcement action has occurred. That's what's compiled in that packet.
So it sounds like you would not know if the inspector had notes that were not in that packet because that's all you would receive.
That's what
Okay.
we rely upon in pursuing these matters.
And that there are no requirements from your office other than those forms and the method you just described that the inspector would provide to you to take this to the case. Is that?
Yeah, we would, or we would meet with them individually to ask them questions in relation to the documents that are before them.
Okay. And are you aware, you alluded to a certain period of time that documents were held. How long are documents held by the district?
That I don't know. I know, and I haven't dealt with this issue recently. I'm just talking from my experience, which, may not be exactly on point for the questions being asked right here. But typically, what a prosecutor is interested in is the final product.
Okay.
And because is within the deliberative process in the Public Records Act, consistent with that is we ask that the people that deal with enforcement activity just give us that final product and that they not retain that other information, because clearly in formulating their thoughts, taking their notes, making observations, it would create a conflict or in that maybe something they noted or observed, which is, I think, why Mr. Bruin wants this information. If there's any contradiction on those two things, it's typically going to be inferred against the information making, the person making the findings, and it, I would argue, serve as a distraction, because what they should be held accountable to is the final findings in which they base their enforcement action. And that's why usually the recommendation is that you destroy your notes after, you have to live with what your final determination is rather than any notes you take along the way.
Okay.
I've
Things
seen,
have changed, because when I was an inspector, we saved all our notes. That's why I was just wondering, and they would be in the file that you're referring to. So, okay, but you're saying that that's not the procedure, so.
I've seen the inspector reports on the notices of violation, not on this case, in other cases. And What I've seen is that they are extraordinarily thorough. Ms. Brusay?
Are you calling upon
I
me?
didn't testify. I didn't take the oath.
I have to admit, I'm a bit on the fence. I certainly would say that the phone records themselves, meaning phone bills and dates and times, those aren't, in terms of relevance, I would say they are low on the relevance scale, and I think the burdensome nature and the non-probative nature outweighs that. As far as contents, the reason why I'm on the fence is because of Mr. Sanchez's representation to us that it is the district's instructions to, maybe I'm not using the right word at this hour, or their policy to have inspectors destroy their notes, which makes me think it's not very burdensome to look back over. And if there are remaining notes on the content, it may have some probative value. I do understand Mr. Sanchez's argument with regard to muddying the waters, that the investigative file, the final investigative file is really the more weighty and may have contradictions, and the deliberative process is important to go through. But I'm on the fence.
With respect to the number of such notes, if they are a small number, then it's not burdensome. I don't think I can agree with that. You still have to look in all the same places. You just will find fewer items, and not any less burdensome. Okay, we've talked about this. This is number 22. How do you all feel?
Pretty good.
Ms. Byrd?
Based on our discussion and including your last comments, Mr. Chair, I think that I don't feel the need for this particular item in the subpoena. And I do think, while it may take some time, if respondent chooses to ask witness for notes, if they have them, then it could be determined at that time whether there were any notes that existed.
So you're in support of
So
quashing
I'm in
that?
support of quashing them.
Oh, she is in support of quashing, as am I?
Partial.
Quashing that
Okay.
portion, yes.
Well, providing the notes, if they're available, and it's my understanding they may or may not be available. Is that, what is your motion? Restate it, Ms.
She didn't make a motion, she made a comment.
Comment.
Could you restate it?
See if I can remember what I
Restate your
said.
comment, please.
What I said was, well, based on the discussion, and I guess I come from an antiquated time when we actually stuck all our notes in a folder and, in the drawer when I was a field inspector. But based on the discussion, I think that because things are not clear as to where they are, how they would be found, whether they were burdensome, whether or not they even exist, that I would allow for respondent to ask questions of the witness when the witness was available. And while it might take a little more time, if there are notes at that time, for the witness to then request those notes, I think that I would still do that, and that I would quash number 22.
Did you understand that?
I sure did.
Okay. Any other thoughts on number 22? Ms. Prusak?
I think I'm convinced. I base both Mr. Chairman Cameron on your correction to what I said as to it would still be a large burden to find the absence of those notes. And based on, Ms. Byrd, what you're saying regarding the ability of respondent to ask questions during cross-examination, I think that I would be in favor of quashing this, of approving them, granting the motion to quash number 22.
Mr. Sanchez did state, however, that according to the practice, they do not require the inspector to retain those notes after a certain point. They could hold on to them or destroy them, delete them, whatever. That being the case, the only place he can probably get them, in addition to information, if it's available, is when the witness is testifying or subpoenaed to give a depo or whatever the case may be. So I agree with my colleagues that we should squash this motion to request.
Squash or quash? Okay. Okay. Shall go on to 23. You want to make a motion on the individual? Okay.
Okay, yes. In the matter of South Coast Air Quality Management District versus Browning Ferris Industries of California, 3448-14, I move that we grant the motion to quash with regard to number 22 of the subpoena.
I'll second that. Discussion on that motion. No discussion. Dr. Lerner, how do you vote?
I vote to quash and squash.
Squash, yeah.
Ms. Byrd?
Yes.
Senator?
Aye.
Thank you. Motion passes 5-0. On to 23. On 23, the respondent is asking for all records and communications referring or relating to the district's payment of overtime or other additional compensation or benefits to Mr. Israel, etc. Respondent feels that the compensation provides an incentive. I just can't not support that.
I agree with you, and I want to point out that if he gets a serious call at 5:05 and he's working at 5 o'clock, and he goes home at 5:30, he's going to go out there, and it is going to be overtime. So he has to go out there. He's not going to go out there to make overtime for a call that comes in at 2 o'clock in the afternoon. It's just not something that needs to be done. And it also casts aspersions on his ethics. I just think we need to keep that away from this. I think you need to know when he went out and how long he was there and when the call was made, which all comes into the file for that particular phone call. And we can end that discussion. I think this is really trying to give the appearance of more guilt than it's inappropriate. It really is inappropriate.
Ms. Broussard?
I have to say, parties have a right to impeach witnesses, and I think it is appropriate were what they were requesting probative of bias. I do not believe that is probative of bias. And I heard Mr. Bruin's argument regarding their belief that it would be probative because it gives some kind of incentive, because if Mr. Israel does not only respond, but, I apologize, not only respond, but actually confirm the existence of odors, that would chill people from calling him at night, and somehow then he would not make that money. That is, as Mr. Sanchez said, extremely speculative. And so I would deny it just based on the low probative value.
Anyone else?
Yeah, I agree. I don't think Mr. Israel's looking for work, go work late at night, and he's got a family, I'm sure. He would rather be at home. But duty calls, and we all respond when asked to do so. especially if that's our assignment. So therefore, I would move to squash and to quash.
Yes, there's a motion on the floor, Ms. Bruce.
I actually didn't make the motion, but I will. But I just want to be clear. This board needs to be careful about making determinations of credibility before witnesses appear before us. So the respondents have a right, again, to impeach all witnesses. It's merely we are determining today whether to grant a motion to quash because what is requested has very low probative value. And that is the basis for my motion, which I will make now. In the matter of South Coast Air Quality Management District versus Browning Ferris Industries of California, case 3448-14, I move that we grant the request to quash number 23 of the subpoena.
I'll second that. Discussion on the motion. Dr. Lerner, how do you vote?
To quash.
Ms. Byrd?
Yes.
Senator?
Aye.
Motion passes 5-0. I think except for the schedule, we've covered everything.
I had thought that. However, I believe Mr. Sanchez says there's still a dispute as to the other items with regard to the time frame. Am I wrong on that?
I think Mr. Bruin indicated that he was in agreement for the time frame of October 13th, 2013 through July 12th, 2016, that all the remaining items, absent 1 through 10, which were removed and resolved with the protective order, the district will produce in accordance with that time frame.
That's correct, Mr. Chairman, and if the board prefers, I would be happy to take our original subpoena and revise it to reflect the board's rulings today and delete those items that the board granted the district's motion to quash on, as well as the complaint data that we agreed to withdraw, and run the form of that subpoena by Mr. Sanchez, district counsel, so we can make sure we're all in agreement, and that way you'll have a written subpoena in final form that will reflect our agreements today.
Clean copy, yeah. Yes, please. Okay, and that includes the custodian of records subpoena, that's going to be held in abeyance.
Correct.
Okay. And so now do we have only the schedule to consider?
Yes.
We're off the record. Okay, we're back on the record. I'm going to mark the proposed schedule, revised proposed schedule, as exhibit number 2 for the district. My thoughts are to set the first 4 dates of for the evidentiary hearing as October 25, 26, and 27, and hold the rest to be determined later. Any objection with that schedule for the moment? Ms. Senator?
How does it satisfy Mr. Sanchez's suggestion that we should have included the 29th and the 5th?
We can still do that. My thought is to wait for a bit. My thought is to wait for a bit before we firm up the rest of the dates. One of the problems we have is we don't know if there is a suitable venue available for those 2 Saturdays.
Mr. Chairman, only under page 2 of this schedule, there's one dot that says that there's no venue available.
Mr. Sanchez, is there a venue available for the
Granada
29th?
Hill, they said no.
Yeah, well, we haven't identified a date yet. Obviously, we're waiting for the board's ruling today to go and search for venues in the area.
So on the 25th, 6th, and 7th, the complainants have to come here then.
They would if they would want to. On those days, we would begin the evidentiary hearings. That doesn't, but any citizen who wished to could come here, and on that date, they would have the opportunity to, they would sit in and hear what's going on. They would also have the opportunity to view the proceedings on a webcast, so they wouldn't have to come in. However, those dates would be devoted to the presentation of the petitioner's case. And we would, so that's it, that's my answer.
So you're saying they would be all properly notified that the hearings are taking place to the individuals who could show some interest to be here, would be here, number one. Number two, Mr. Sanchez, when you put in your case, you have any reason to believe that your witnesses, the complainants will not show on these dates?
I will let the board know immediately if there's any problem once we contact them with the schedule. Obviously, the goal would be to keep a continuous hearing, and any days that we could hold here, for all the reasons raised by the board members, I would also like to hold those here. But if there's any problems and we need to facilitate one or more days in the community on the Saturday, I will let the board and Respondents Council know that that's what we will be seeking to, and let the board evaluate those requests at that time. But I would appreciate at least one Saturday if possible, and then request additional days if necessary. I think one of the issues raised by Respondents Council, and we don't need to decide that at this time, is whether we're going to have deliberations in the community, and as the chair and vice chair and member Byrd experienced in a similar matter ongoing, which we'll need to discuss in the future, is how do we address members from the public that appear at each hearing and ask to testify each time, for expediency and the scope of their testimony. How do we address all those things to keep the process moving in an efficient manner? But I would like at least one Saturday, if possible, scheduled for this time, so I can identify with the witnesses who have made complaints to try to coordinate their scheduling.
Mr. Chairman, this is about 2 months away on the 29th of October, and the staff has been, in my view, fairly proficient in finding a place where we could meet conveniently in the Valley area, Granada Hills. So this being 2 months away, they've given enough lead time to find a place where we can meet if it were necessary to do so.
On the 29th of October, we will not have concluded the evidentiary portion of the hearing. On the 29th of October, we will not have heard closing statements. Having already had a Saturday hearing, I'm wondering what value there would be to having a Saturday hearing again prior to the time that we have concluded the evidentiary portion and prior to the time that we hear closing statements. I think before we hear closing statements, maybe that's a good time to hold a Saturday hearing to give the public an opportunity to speak to us about that which they have experienced in the interim, and perhaps comment on any evidence that's been presented to which they will have had the opportunity to observe and hear over the webcasts. So I think Saturday, the 29th of October is too soon. Ms.
Mr.
Prusak?
Chairman?
I called on Ms. Prusak, then Senator.
I thought I heard Mr. Sanchez had stated that he is using complainants and as his affirmative case, and the opportunity to examine them on Saturdays. I think sounds to me, as a member of the board, to be a more important use of a Saturday than to just hold our deliberations in the public. We make ourselves available here we went out already on a Saturday, made ourselves available for public comment. We're always available here for public comment, and I think it's more important that we gather the vital evidence for the case.
Is that what you would envision for the 29th?
Yes, Mr. Chairman, and just to clarify that that's exactly what Ms. Prusak articulated. Just my concern is why I had asked for 2 Saturdays, but we can visit it and see how things go on the 29th if the board agrees to that date. Was just, how the scheduling went and the timing went on last Saturday, assuming, there's going to be cross-examination and questioning of the witnesses and their motives. I just would, be upfront with the board. It may take a little bit longer than we even had on some of I think we only had 2 witnesses in the morning, if I wasn't mistaken. So it may take a little bit longer, as you've seen, as with the contested matter, what's going to be at issue.
Yeah, it all depends who the witnesses are. Senator?
Mr. Chairman, members, maybe I'm wrong, but I'm under the impression that the closing arguments don't take place until after the respondents put on their case.
Yeah.
So how can you, I don't know, it was stated that the 29th was, that's when they're going to put in their final case, respond to. I think you used the word, that's the closing arguments. And the closing arguments don't take place until after the respondents put on that case. Therefore, that's going to be sometime after, in November.
Yeah. What I had suggested, and I'm convinced otherwise now, is that we hold off on the Saturday hearing until just before the final argument, the closing arguments. But Ms. Prusak and Mr. Sanchez have reminded me that the district's case will include public witnesses, and for that reason, we need a Saturday as during the district's portion of the presentation of their case. Ms. Byrd?
I just wanted to throw something out there. There was one case that we heard in an evening, and I also recognize that there have been some other government agencies that have gone out on some very major cases, and they have been in the community in the afternoon, weekdays. And so what I was wondering is when this discussion comes up as to when you might hold when we might hold our next community meeting, if it might be considered that we do an afternoon into the evening. If we're going to the community, there may be people there, and this might even give you some more flexibility as to the different witnesses that you may have. There may be some that could come one day versus some that can come another day, and I think that might also be able to assist us in moving along a little quicker if that's possible. I don't know, but I'm just thinking that maybe if we include that option and not just limit it to which Saturdays we might be able to have.
I'll explore all options. Respondents Council and I will talk. I will talk about availability. You know, securing the venue is always the biggest challenge. Then I'll talk with our Public Affairs Office. You know, I have no problem of breaking this hearing off in portions to facilitate all those things and our time availability. I know both council here are not local, so, you know, all those factors will come into, but I will not preclude considering the things that you're suggesting.
Ms. Prusak?
It sounds like timeliness is important in terms of securing venues, so perhaps it would make sense to set those first 3 dates and a pre-hearing conference to discuss further dates once availability has been assessed fully, and those things can be vetted during a pre-hearing conference.
Senator?
Mr. Chairman and members, in order to, Mr. Sanchez, to assist you in the expedite these hearings in any way, I will cancel, I'm prepared to cancel everything I have planned or have not planned or plan to plan so that you can move it forward. And go, any day I'll be available.
That's very much appreciated, Senator. That, okay. We're going to need a pre-hearing to talk about these things.
I'm sorry, Daddy.
We're going to need a pre-hearing to talk about these things. Mr. Sanchez, Mr. Bruin, might you all be available, and might you have information ready for us for a pre-hearing on the 8th of September?
The district would be available on September 8th.
2 o'clock?
Will this be by phone and in person?
By phone.
Okay, I'll be available, and I think Mr. Beck will.
Okay. So we'll set a pre-hearing at 2 p.m. Thursday, October 8th. 2 p.m.
September.
September 8th. Thank you. Anything else we need to discuss, Ms. Prusak?
Just to, I think, to continue the hearing to October 25th.
25th? Right. And for the moment, set the evidentiary hearings for 25, 26, and 27 of October.
And I would just propose, Mr. Chairman, as Respondents Council will prepare the other documents, I can put this proposed schedule in a pleading format. I will remove the dates that we have not agreed to and put, you know, to be determined, and we can continue to fill out this document as we have further orders issued by this board. But if you would like, I can prepare that with coordination of Respondents Council.
The chair would appreciate that.
Okay, thank you.
Any other business? Ms. Byrd?
And I'm not sure if I understood this correctly. Do we have to have a motion to accept this schedule? Because in lieu of the motion in limine, we were to accept a schedule. Is that what did I understand that?
Ms. Prusak?
I don't think we need to do that because it was Mr. Bruin's a representation that it's so long as he's given adequate amount of time to review the records that will be produced to him, which would mean starting October 25th, that he was withdrawing the motion in limine. If we understood that, then we don't need to make a motion.
That's correct.
Thank you.
I'm taking it that the board has approved this schedule in terms of the deadlines for filing various documents with the board.
Yes, the pre-hearing deadlines that are at the top of Exhibit 2.
All right, thank you.
Ms. Prusak?
I still see 2 days prior to a hearing in there at least once. Was this agreed to by this is agreed to by the district? Okay, so everything is clear to all the parties? Fine.
And that'll be included in Mr. Sanchez's revised schedule.
Yes.
Anything further? Hearing board, the chair appreciates everybody's patience and understanding, and we look forward to proceeding with the case as quickly as possible, but giving everybody the right to prepare their case.
Thank you, Mr. Chairman.
We are adjourned. Hickson is off. Okay. There's no hearing tomorrow on Hickson? Nope. You can stay at home. Well, you can stay wherever you want to stay.
Yeah, we'll catch up. Say again? He's gonna run the restroom, I said. All right, I notified him and everybody on the team the schedule.
Okay, cool.
But we'll need to get him that sheet as it was I actually sent that to Bob, so he's got it.
Which sheet?
The one Nick sent around, has that been amended since then?
You talk about the hearing schedule?
Yeah, this pre-hearing schedule did get changed a little bit from what I sent around, so.
Yeah.
What was that?
I just cut it too,
Ooh, that happens to me.
that one's gonna hurt.